to 72.
63 after 2 weeks matter.
February last week.
73 to 87.
74 and 75 prefer adjourn. 74 and 75 prefer adjourn.
76 and 80 withdraw, my
1 minute. 76, 74, 75. March first week. Yes. 76,
80.
76 and 80.
80.
Withdraw.
My lord, item 85, kindly withdraw.
Yes. 85, what do you want, madam?
Withdraw.
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 Memo.
Memo. 85. Yes.
Pray for it to matter. Pray for it to matter.
Let me complete the list first.
Memo.
I know we have started the list. Let us complete the list.
Sorry.
Yes.
88 to 101.
88 to 101. Yes. Next.
102 to 150.
Yes.
116 to 122.
Yes.
123 to 128.
Yes.
129 to 132.
All must be interim order. Forget it. Yes. Next.
133 to 140.
Item 140, it will be taken up along the other number of cases. I have given the list.
But let the other side come, because these are after notice matters and they'll give great problem. Yes. Mentioning. Sir.
141 to 147.
Rest matter.
Yes.
Rest matter.
Yes, sir.
Rest.
Give it. Yes.
Pray for it.
For it. What are the urgency? Because I am listing the matter, everybody is asking for adjournment. What are the urgencies? Do you have any urgency?
Tired of bail matter.
Okay. Yes, sir.
Tired of bail matter listed on 22nd due to absence of lawyer. Continuously, it stood adjourned.
Urgent to?
January 2025.
You don't come, then what to do?
I have filed 2 applications to prepone the matter and other effort.
Just check the bail.
May I please, your lordship?
As it has been.
Bail matter, I don't want to adjourn, but nobody comes, then what to do?
That is, it was on 22nd,
Yes.
and that previous date, your lordship was pleased to adjourn for 10 days only. But unfortunate for the client.
For the, your client must be interested to stay there and.
Yes, ma'am, that application and everything I have given.
Okay, we'll see.
My lordship, item number 64 and 65 may kindly be adjourned.
Why adjournment? I don't understand. If everybody is asking for adjournment, why these matters are listed?
Lordship will need to file certain documents. Lordship.
All frivolous petitions are being filed and it is pending.
Lordship will need to file certain
I am
documents.
unnecessarily listing these matters. Adjourn it to March.
May I please, Lordship, pardon my
Go
lord.
to March. March end kar do.
This is basically
Unnecessary wasting. Yes.
compromise between the parties.
Offense?
Offense, the 76 and other allied offense.
Also is there.
I have gone through that reason, but I think this will be an exception.
That's the problem.
No, the 10 days back the decision has come. I am conscious of my
That's the problem.
May I please, Lordship? Lordship, item number 141, my lord, on behalf of Mr. Bahali. And the father Sadha Karma was out of the Kotaka, so kindly maybe
141,
my lord.
interim order must be there.
My lord.
Wait.
And after 2 weeks, my lord.
Wait, the other side should come.
My-
Other side should come.
Yes.
Yes. Yes. Start.
Deeply.
58.
Yes.
Last petition, the lordship directed me to status of the investigation.
Yes.
And I obtained instruction, the investigation completed, and we are awaiting for sanction to file that.
What is the case is about?
There are three cases. So that's the investigation. Your lordship last petition, why traffic has not been fully.
Let it counsel for the additional standing counsel for the vigilance submits that the investigation in the present case is completed and
step to obtain sanction for
the sanction order is awaited. Hence, the charge sheet has not yet been filed. lease the matter. This January. For further instruction, yes.
59,
Yes. 59. Password. Yes.
59 here, my lord, check certificate.
59. Password. 60. Yes.
61,
61. Yes.
One officer directed to open instruction.
Hmm.
The status of the investigation. There is come on 13/5/2024. So he has instructed that carrying out the same and completion of investigation. Final charge sheet against the accused will be submitted at an early date. Sure, thereafter the
No, what is the stage?
case matter from 13/5/2024 charge preliminary charge sheet has been filed.
Huh?
Reliance has been taken.
Huh?
Thereafter, my lord, he has again and again filed petition for this honorable has referred. This court has stated, this honorable court has stated that you file a discharge petition. Then he has filed a petition with a prayer to submit the final charge sheet and also to discharge. That has been rejected, and subsequently he has filed a miscase stating that charge has been framed.
There is no interim order. Non-appeals for the petitioner in the interest of justice adjourned. Yes.
62,
Yes.
The counsel for the ED had taken an adjournment to file a reply. That I don't see.
Nobody. I'll pass it over, let us see. He has not filed reply.
No.
Let us see, he may, then if he files the reply, then I'll give you an opportunity to read it.
What I am submitting is
Yes.
let it be passed over. Because in his presence, if your lordship may grant an interim order.
Okay, let him come. Pass.
66,
Please, Lordship, today we have filed an IA for implement of the opposite parties.
Why are you doing all installment? I don't know.
Lordship, the petitioner came yesterday and
Which I,
it is not on record, Lordship. In course of date, it is being filed.
then counsel for the petitioner submits that today they have filed an IA seeking impleadment for the informant.
Opposite parties, it's accused persons.
Accused persons, being the opposite party, the IA is not, has not come on record, leaves the matter in February. So, yes.
Oh, Lordship.
67,
May it visualize.
Yes.
Here, my lord, that case, my lord, where the vehicle was intercepted on the way and rupees 2 lakhs was recovered from the
Yes.
petitioner. I got the answer put by my lord, that is by lord 2021, this is online, check error decision for Quashing. And I'm preparing a short note for that. And my lord, peculiarity is they have fixed up a check period for 10 years. My lord says for 1 day. My lord, I have got the letter given by them, given by the vigilance to the petitioner, that the check period is from my lord 2005 to 2015. My lord, 16 2000, my lord, let me see.
This is the letter given to you.
And accordingly, my lord, I was directed to produce all the documents. I had produced all the documents. They inquired from 2015 to 2023 and ultimately found nothing.
But also, I have got the decision. It can.
But how will you deal with that? What is the judgment? Let us see.
My lord,
Kerala.
it's a case for Quashing. 2021 SSC Online Kerala. They have taken note of the Apex Court judgment also 2001 Supreme Court. My lord, My lord, may kindly see for paragraph 9. They have section 13(1)(e) has been quoted and it has been construed. Relying upon judgments with regards to 482, how court can interfere and what circumstances court can interfere. Everything has been taken note of. And the basic decision on the point, my lord, is the AR 88, Supreme Court page 88. My lord can also see that. AR 88, Supreme Court page 88, State of Maharashtra versus Polanji Darawasa Darwala.
Darwala.
Darwala case, that is.
Check period.
Supreme Court, Honorable Apex Court has deprecated the practice of my lord fixing 4 months, fixing 3 months, fixing 1 year. When a government servant has retired without a single black spot in his career, how he should have dealt, my lord. And that too, my lord, I have also got documents to show. Before 2015, my 2 sons, one was a major during that period. He was drawing 1,70,000, and my son, my another younger son, my lord, he was in cognizant in America, and he was drawing 1 crore per year, my lord. I have got the salary certificate.
No, that is not the issue. Issue is
My joint family, my
you may be having that, but the currency which was seized to you,
2 lakhs.
you gave an explanation.
My
You
lord,
could have given the explanation, it is from my son's income, whatever. But you have given
not necessary, my lord. Court says not necessary. Court says, considering 13(1)(e),
So it is necessary that he has to give estimate.
No, no.
And in interception case, even if for a day, it can.
Then take check period you have.
Check सेटा तो कौन मेंशन कर सेटा ऊपर मत देखियो यदि से कहिता चेक पीरियड देखियो पर कौन है
5 to पदर करछथि.
Then place it. Please give it. I'll fix it up 1/7.
let him
7th.
Not 7, on 9th. 9th or 10th. 10th.
काहे कि ना let it verify कर से आईओ ट्रांसफर है chúng ta काली डाकी किंतु सेक मु कहर I am also
11, 12.
16 has to
Okay, 16th. Okay, 16th. Give the copy to.
I'm also preparing a short
Please
book.
give.
that दोजन मत एउटा कपी दे दियो so that in advance देले मु so that I can take instruction
Yes.
from them it will for you to I cannot advance my point of
Well,
You please,
not there anywhere.
please supply a copy.
Well, it's not there anywhere that they have fixed up the check period for 1 day. Rather, its document is there. They have fixed the check period for 2005 to 15. In between, I was retired. I got my GPF around 40 lakhs or 50 lakhs. I got all the documents. They are official documents. And after perusal, everything, they could not find a single thing in my house.
Now, what will be the situation? Suppose
Yes.
they fixed the check period.
Ballot.
And in that check period, you have sufficient income, no problem.
Ballot.
But
They are also ballot in Kerala.
No, but
in Kerala case, 56,000 was recovered intercepting his vehicle.
But if you give a explanation which is palpably wrong, what will happen?
Why I have given that 2021 SEC online? In that Kerala case, vehicle of RTO was intercepted on the way. Rupees 56,000 was recovered. Court says, even the 161 statements I cannot take note of. But you have to take note of that he is a government servant and he was having 30 years of service behind his back. How can you ignore it? Court has considered it and relying upon Apex Court judgment.
No, all these things are correct. But what I am asking something else.
Yeah.
Suppose 2 lakh rupees is intercepted from you. You are asked to explain. You have given an explanation. That
explanation is substantiated by 2 persons where I have given the.
Then that explanation is required to be considered. No, kindly appreciate one thing. The explanation is required to be considered on facts or the income for that period is taken into consideration.
88 Supreme Court, 88 Kerala says explanation is not necessary to be considered. Income is to be considered.
Then you have
valid. I have.
Supreme Court recent judgment is
The
Suppose he says that I got the money from XYZ source. If you are after that source or after his income, if 13,
2021, 2021 SSC online.
explanation is important or his income is important.
The explanation is here is
Explanation is important.
not important. That is there in the judgment.
Let it come.
Okay, it's an interesting point. Let us.
Very interesting point.
Very interesting point.
My learned friend may take note of 2021 SSC online Kerala.
That will be better.
You just give the copy.
So that better. কারণ আপনার পাখে পুরোনা ছিল ମୋ পাখে পুরোনা নাই
পুরোনা ছিল নাই ছিল মানে
পুরোনা जो
SSC online টা পুরোনা কোন নয়া কোন কম্পিউটার আছে
हां सब मिल
ଅଛି ସବୁ একটা କରୁଛନ୍ତି ମୁଁ ଦେଖିବି ଟିକେ ଆପଣ ଦେଇ ଦିଅନ୍ତୁ ଗୋଟେ କପି
यार କିଛି କହିନି
16
ସବୁ online
ଆରେ
68
Mallet that interim
or to continue.
Pardon your lordship. Actually, I was there in court number 16 for one mention. My item was 58. That vigilance matter, your lordship may recall. Last
I have urgent.
report was called
Yes,
for.
urgent. Yes, next.
68
সেটা
68.
May I please, I mean, VC lordship. I may be allowed to.
Yes.
Lordship, in this case, I have challenged the cognizance order dated 2/8/2023. Passed in 1cc case number 34 of 2022. That was passed under section 138 of NI Act, lordship.
Yes.
Lordship, I am taking lordship's kind attention to the factual matrix of the case.
No, what see the cognizance order? Factual metrics, I need not go at the cognizance stage.
Because that is important. Lordship, for a moment, taking the check was bounced twice. In earlier one notice was issued and that has been properly replied by me. Then after that, the second time the check got bounced, and the second time also I got gave the reply. But the Lordant trial court did not hear that, and the time it accommodated the limitation time that is strictly barred in this under section 138 NI Act case. So that's why I am taking lordship's kind attention to the factual matrix of the case.
Nay, I understood. Show me the judgment.
For a moment, I am taking lordship's kind attention to annexure 2, that is page 24, lordship.
Yes. Yes.
Lordship, kindly come to
Yes.
lordship page
Your entire petition is consisting of 29 pages. Where are you searching?
lordship page 26.
Yes.
That is by my reply notice to the second time the complainant gave me the notice, that is on 27/12/2021. Second notice was given to me and I replied the same on 27/1/2022.
Yes.
In that, I have written that it is for your information that the alleged money has been paid to your client in the presence of the
Sir,
witness.
in lieu of the check which you have issued, in the reply you are saying that I have paid back the money. These are disputed question of fact. It has to be decided in the trial. I can't at the cognizance stage perhaps go into all these questions.
No, but
The fact remains that the check which was issued by you, you have not disputed. You say that I have paid back the amount. Then these are the factual dispute. It has to be established in trial. Because the presumption operates against you. What to do?
But the cause of the check that is got bounced, that is the check was not issued. That is the statement.
In the reply, where have you said that?
Yes, I have said it.
This is.
Lordship, kindly come to page 27.
I'm there only, 27.
27.
In the first notice, you have not said, I have paid back the money, you said.
Lordship, that it is true that client was taking the third paragraph, taking his own checkbook in a bag which was missed somewhere en route from.
Oh, this is again another difference.
Lordship,
I don't think I can enter.
Lordship, because Lordship kindly come to next.
In the first notice, in the first reply, you don't say anything. In the second reply, you cooked up another story. All these things can be tested in the trial only. I can't go into it.
Lordship kindly come to page 29.
Yes.
29 for a moment.
Yes, yes, sir.
That is my FIR.
Yes, I know. I have seen it. I have seen it. You have given in the Go police station that you lost the check. That you can lead the evidence on this respect, right? And petitioner is the accused in ICC case number 34 of 2022, pending before SDGM Puri, initiated by opposite party for alleged offence under section 138 NI. By the impugn order dated 2/8/2023, the court below has taken cognizance of offence punishable under section 138 NI against the petitioner. The petitioner is agreed by the same, and hence this petition. Let counsel for the petitioner has taken me to the reply to the statutory notice given by him, and submits that he has specifically taken the plea in the reply that his checkbook was lost somewhere en routing from Choitana to his own house at Gob, Kushupur, for which he has also filed a complaint before the Gob police station, while complaint dated 2/10/2021. He further submits that despite these facts which are in emanating from the record, the trial court has not taken into consideration and went ahead to take cognizance of the offence. Hence, the cognizance order is valid law. I'm not inclined to explain this petition at this stage because the fact of official case is somehow not denied by the petitioner in specific terms. Hence, the presumption under section 139 operates in the state. Therefore, the petition doesn't deserve a merit. Accordingly, the same is dismissed. However, dismissal of the present petition shall not preclude the petitioner to raise all the points before the trial court at appropriate stage. With this observation, petition is disposed of. Yes, next.
69.
May I please? 69. 69 here last time I ordered that. I have to direct the state to produce the case diary. Taking note of my contention that it's a case where, my lord, through a complaint case was filed without disclosing the fact that whether the complainant has prior to it approached the concerned police by filing a FIR or also to the concerned SP against that, my lord. So because of the fact that thereafter they filed a complaint case, it was sent for investigation under section 150/3 without the magistrate has also not complied the apex court judgment in case of Priyanka Srivastava versus State of BP, where it has been specifically directed that all the magistrate, while before sending it for under section 150/3, the magistrate is duty bound to examine whether the complaint petition is supported with the affidavit declaring that in fact any prior information has been lodged before the police, as well as the
specific
yes,
detail of
and they took detail all details.
Have you got it, sir?
affidavit
Let him get let
I affidavit nahi because I have filed the complaint case. The affidavit is not
but the state submits that he has not obtained, he has not received instruction in this matter, hence he seeks an adjournment for a week, leaves the matter after 1 week.
Date we could.
Yes, next.
Last time it was my prayer because I have lost my lord in the that anticipatory bail. May I pray no course of action. one for the petition is also.
No, after 1 week, if it doesn't happen, then I'll do.
Last time, my lord said.
Late, because anticipatory bail in 482.
And the allegation is theft of and this.
I know. Once let it come, it may be quashed also. There is nothing. Yes. Yes. 70. Pass off.
71.
71, my lords, NIA case, my application for recall of witness was rejected, my lords, which is why the annexure 4 at page 21.
4, huh?
What is?
4. Yes.
Let here 138 case. Once PW1 was called. Second time, my lord, for some
PW1 is the complainant.
complainant.
Yes.
Let me, what I pray, my lord, if there will be no objection, my lord, is date being fixed, I will pay for the cost. 3-4 questions are there.
Where is your application?
That is, my lord, 17, page 17.
The objections are all.
Annexure 2, my lord, may see.
No, then I'll have to issue notice. Because he has filed objection
My lord.
to your application
My lord,
under
yes,
311.
Yes.
If there would not have been an objection,
My lord, my lord.
straight away come.
Complaint case objection would be there, my lord. It's a complaint case.
Generally, they orally they do it, but written objection.
Is opposite party number 2.
Issue notice next week.
My
Put it
lord.
next week, I'll give one opportunity
My
for
lord.
you. Next week, yes. Take out notice immediately.
My lord, tomorrow, by tomorrow.
By tomorrow.
By tomorrow.
Notice to.
And in between, if I don't know whether the date is there or if I will file an application, it will be
in between application. Complaint case. Yes.
because we are now in that format because of vigilance cases.
Yes.
72.
72, my lord. Petitioner and the OP number 2 is two sisters, my lord. For property dispute.
Petitioner and
OP2, the informant.
okay.
And this case is not maintainable. Only notice goes, let him later appeal.
Petitioner and opposite party, they are sisters.
Two sisters, my lord.
Okay.
I am the younger sister.
Yes.
She is my.
What is the dispute then?
ଜମିକି ନବା ପାଇଁ ସିଏ ନିଜେ fraud କରି ତାଙ୍କ husband police officer.
I'll issue notice.
And as per Supreme Court judgment, recent judgment, my lord.
Look, after all, your sisters will see that
Yes,
how
yes.
things are. Yes. Issue notice written about so and so. What is the stage?
କିଛି ହେଇପାରୁନି.
Investigation is going on.
ଆମେ anticipatory bail ରେ ଅଛୁ.
Acha, you take out.
Investigation ବି କିଛି କରୁନାହାନ୍ତି, ସେ ବସୁଛନ୍ତି.
Shall I send it to charge sheet has been filed?
Charge sheet both not yet filed, I think.
Then I am issuing notice. Call it.
Okay.
Call it.
Mediation
What are the offenses, by the way?
420.
420.
We'll settle it. Bring it.
My lord.
Bring it. We'll settle.
No, we are. ସିଏ ଅଧିକା ନେଲେ ବି ଆମର ଦୁଃଖ ନାହିଁ. ତାଙ୍କ husband police officer ତେଣୁ
Earning more.
ସବୁ ମାନେ ମାକୁ ଛାଡ଼ିଦେଲେ ମୁଁ ସବୁ ସେବା କଲି. ତା ସତ୍ତ୍ୱେ this is my
Like the story.
ସେ ଅଧିକା ନେଲେ
Any family what?
my lord, I have no objection. ସିଏ ଯଦି ଅଧିକା ନିଅନ୍ତି 60% ମୋର ଆପତ୍ତି ନାହିଁ. କିନ୍ତୁ ସିଏ ତାଙ୍କ ନିଜେ ବିକି ସବୁ ନେବାରେ ବ୍ୟସ୍ତ ଅଛନ୍ତି. ମତେ କିଛି
Let them come. We'll sort it out. Yes.
73.
Proceeding that the complaint case matter protest petition are filed by the appeal number 2 on the ground of lordship. This is a dispute minors that the daughter of the informant marriage was fixed with the nephew of the present petitioners matter. And the prosecution case is that my lord, before the marriage, they have given 10 lakhs rupees as a advance dowry and 85,000 for dress, my lord.
Marriage is not.
Marriage could not be solemnized. And because of that, my lord, the FIR was lost. That is the prosecution case as per the FIR, my lord. Then
How much they have paid according to them?
10 lakhs, my lord, and 85. 10 lakhs total.
How much in fact they have paid?
They have paid, my lord. They have paid, my lord. But in fact, your lordship may kindly turn to the investigation report that is final form submitted by the investigating agency, running page 44, my lord. 44, my lord. Relevant.
Yes.
Thus, there was no conversation among the about solemnization of the marriage or demand of dowry money to the respect.
Then why have you taken that money? Yes, my lord. That is my lord, the investigation reflects, my lords. Because there was a transaction, my lord, business transaction for the for a truck, my lords. And for which, my lords, both the parties, my lord, I had given, my lord, 18 lakhs rupees, and they had given to us, my lord, 10 lakhs 85 rupees. And that is also removed from the investigation, my lord. Lords, permit me to read that, my lord. Yes. Thereafter, complaint case filed. Thereafter, complaint case is filed. Protest petition. My lord. And that apart is the peculiarity, lordship, if your lordship will permit me, in the meanwhile, they have filed a money suit before the court, civil court, Bhubaneswar, which is I have not annexed because later on they have filed money suit, bringing the same facts, my lord. If your lordship, what do they say? The facts said that they had given 10 lakhs 85 for the purpose of Salman the matter of the daughter of the informant, who is the my lord, the nephew of the present petitioner, my lord. How much you have taken? Why don't you pay and finish it up? My lord, it is removed from the investigation that we have paid 18 lakhs rupees. For what? For the purpose of purchasing the truck and my lord, repairing the truck, my lord. That is reduced, my lord. And thereafter, my lord, they are saying, my lord, because of that transaction, my lord, they have also given us 10 lakhs 85,000 rupees. But they have coloring it in another way, my lord. We issue notice, huh? My lord. It's notice. Let us see. Take out notice against opposite party. Unless IA has been filed, when someone suit has already been filed. Suit, my lord. Story is same. Story is same, my lord. Next, the petitioner is seeking passing up the 1cc case number 409 of 2023 arising out of PS case number 117 of 2021 for 21. The next initially the FIR was registered against the petitioner for alleged offence under section alleged commission of offence under section 417 to 294 506 34 and section 4 of DP Act. DP Act. The allegation against the petitioner is that the petitioner, who is the petitioner? Petitioner is the marriage of whose daughter? Marriage of the daughter of the informant, my lord. Who is the nephew of the present petitioner? Allegation that in lieu of the marriage of the nephew of the present petitioner, the petitioners have taken 10 lakhs 85,000 rupees from the informant, and subsequently they wriggled out of their promises, their promises. Hence this FIR. After investigation, the police had filed a final form on 5/11/2021. In the final form, it is it transfers from the final form that there was a transaction, financial transaction between the petitioners and opposite party number 2 regarding some purchase of some truck for which the petitioners appears to have paid about 18 lakhs to the opposite party number 2, party number 2. Therefore, the police, after investigation, filed a closure report in the FIR. Closure report in the FIR. The opposite party, being agreed by the closure report, has filed the protest petition in which the cognizance of the offences has been taken. The petitioner is challenging the same prosecution. Petitioner is challenging the initiation of the petitioner is challenging the entire prosecution. Issue notice to opposite party number 2. Letter counsel for the petitioner also submits that the opposite party has now filed a suit being money suit number 1133 of 2024 before the civil judge senior division Bhubaneswar, seeking recovery of the said amount of rupees 10,80,000. Issue notice to the opposite party, written so. In the meantime, proceeding before so and so state. Proceeding before, you tell me the right court, huh?
My lord,
Which is that court?
my lord, before the learned,
JMFC 4.
4 Katak, my lord.
In ICC number 409 of 2023 state. Yes.
My lord.
Yes.
77.
Deep.
On behalf of Mr. Sunil Panawala, kindly take up the matter after 4 weeks. Kindly take up the matter after 4 weeks.
After
4 weeks. 4 weeks here also.
4 weeks.
Well,
And what is this matter? Whether you have anything on merit?
well,
There are many frivolous petitions filed and they're asking for it.
on behalf of Sunil Panawala.
Recall of witnesses rejected.
Huh?
311% rejected.
So
376 to I and 6 postco
put
is
it,
there.
put in March. Yes.
78.
My lord, January, well.
March. Yes. 78.
My lord, kindly take it next week.
Not next week. Why everybody is asking adjournment? I don't know.
Trap case re discharge petition challenge kar
There must be nothing on the merits.
trap case.
Nothing on merit. March.
79.
$79.
Passing of entire proceeding 420, 467, 468.
Chalo, pass over karo. Otherwise, we'll dismiss.
81.
Yes. 81.
81 was a causing of affair. Raising out of a matrimonial case.
Matrimonial case.
Yes, sir. Sir.
498A.
492, 4
Simply issue notice. Simply issue notice. Issue notice. Yes.
82.
On behalf of Mr. Hon'Ble, challenging order of cognizance.
For the charge sheet, the antecedent is there against the petition. Who anticipated?
No, cognizance order. Why? Why?
So far as the, my lord, 307 is not made out against the
Then
present.
you have to argue on at the stage of charge.
Lordship, may direct.
Alright.
Surrender,
And also for
surrender, first or second.
Petitioner has challenged the order dated 30th January 2024, passed by learned SDJ Bhanjanagar in GR case number 497 of 2023, whereby cognizance of offences punishable under section 341 oblique 323 oblique 307 oblique 294 oblique 506 IPC has been taken against him. NBW has been issued. While taking cognizance, the court below has also issued NBW against the petitioner. The petitioner is agreed by the same impugn order dated 30/3/2024, passed by learning decision and has challenged and has filed the present petition. At the outset, petitioner submits that he would not press this petition insofar as cognizance, insofar as the order by which the cognizance of the offence has been taken. Rather, he reserves right to educate all the points before the court below at the appropriate stage. However, he submits that the NBW issued against the petitioner may be recalled. He on instruction he submits that his client would appear before the court on or before 25th of December and resort to the remedy available to him under law. Subject to the petitioner appearing before the court on 25th of so and resorting to the remedy available under law. Subject to petitioner appearing before so the NBW issued by the order dated 3/2024 by the SDGM Bhanjanagar in GR case number 497 of 2023 shall be kept in abeyance. Kept in abeyance. The petition is at liberty to resort to the remedy available. Yes.
First or second or Sunday, as we can 307.
That I will do it. Yes. Next.
83.
Yes.
That is a fraudulent junction, upsell deeds, impersonation. All these things are there.
What is he asking?
Only FIR has.
Quashing.
Yes, sir. 83.
Yes. Yes, sir. 80.
Sorry, 81.
81 what happened? Notice you. Why is it much? Yes. Nothing is filed here. Investigation is still going on.
Still going on, and the informant is happened to be our senior advocate in our bar association. ଆଉ ପୁତୁରା ମାନେ ଅନ୍ୟ ଜଣଙ୍କୁ ଠିଆ କରିକି ନେଇ ଯାଇଛନ୍ତି ସେଲ୍ ଟ୍ରାଞ୍ଜାକ୍ସନ.
Password to yes.
84. May I lordship? For my lord.
Is the prayer for yearly disposal?
Earlier disposal.
Yearly disposal of what?
But because the accused is outsider, my lord.
Huh?
Accused is outsider. 20 day date also for the FIR is 21, my lord. 8-10 to 21.
You are the accused is not outsider. You have given the cantonment road.
No. He is informant, my lord. Cantonment or the informant, my lord.
So what do you want? Is the informant has filed this petition?
Yes.
Yes, my lord.
What do you want?
My lord, speedy disposal because the accused Gyanendra Kumar Pandey.
16/12/2024 date has been fixed for appearance.
21. How many witnesses are there?
Witnesses are 5 witnesses, my lord.
Right. Petitioner is the informant in FIR number so. After investigation, charge sheet has been filed on 6/9/2022 against the opposite party number 2. Opposite party number 2 for late commission of offences punishable under section 292(2)(a) 506 and IPC read with section 67 of ITA. The petitioner, being the informant in the present case, is seeking a direction from this court for expeditious disposal of the trial. Expeditious disposal of the trial on various grounds. It is the speedy trial being a constitutional and statutory requirement in the law. The petitioner deserves merit to be merit. Hence, the trial court is directed to do and to see that the trial is concluded as expeditiously as possible.
Pardon me, my lord. Time, my lord, may be fixed. 6 months for
time. I can't give. Yes, I give a direction. Yes.
86.
86. In this also the informant has paid for yearly disposal. Yearly disposal of the
early disposal.
Yes.
First order. Expeditious disposal of GR case number 2020. Same order could be. To change take dispose. Yes.
87.
To withdraw your lordship.
Withdraw. Yes. Change GR case FIR number. Yes.
88.
My lord, may I permitted in this matter, your lordship?
Yes.
I am appearing for the opposite party.
And who is the for petitioner?
My lord, this is a if your lordship will see the order, the matter is of 130 cases of 2016. The complaint is of 84 years old. There's a direction from this honorable court to dispose of the case within 4 months. The evidence has already been closed in 10/5/2024 after giving 11 adjournment. And after it has been closed, he filed this case and the matter has been.
What has he asked for?
He is asking to adduce evidence because his evidence has been closed long time before in 2000, your lordship 10/5/2024. That was not been challenged. Here he is praying for time to adduce evidence again. And
Okay, let him come. We'll see. Yes. Yes. No, no, see, pass over, pass over.
89.
Only FIR has been filed.
What is he asking?
Allegation is to wrongfully confine the complainant in the house. Therefore,
What is the stage of the investigation?
investigation not yet completed.
Completed.
Complete.
Completed or not?
Completed. August ମାସରେ ସେଟା ଏକାଟା 22 August.
What are the offences?
Offences under section 126 1 and 351.
Don't tell me the section, sir. You must tell me the offence means section. Anybody can read it. What are the allegations?
ତା ପୁଅ ପାଖକୁ ଦେଖା କରିବା ପାଇଁ ତାକୁ ବାଡେଇଲେ ଶ୍ୱଶୁର ଘରେ ୱାଇଫ ମାର this is the allegation page 8 ହଠାତ୍ ସେ ଲୋକଟି ହଠାତ୍ ମୋର ଗାଲକୁ ଚାରି ଚାପଟା ମାରିଲା ଶଳା ମାରିଲା ମୁଁ ତାର କିଛି କ୍ଷତି କରିବି ପୁରୁଷୋତ୍ତମ ନାୟକ ଚାହାଳି ପ୍ରଫୁଲ୍ଲ ଗନ୍ଧା
Pass over. I'll just pull it up. Yes.
90.
My lord, in this case, the petitioner
also early disposal of the case.
Who are you? You are a complainant.
My lord, complainant, man. My lord, the PS case number has been filed in the year of 2021 and 1cc has been.
Hello.
91.
My lord, on behalf of Mr. Bhuya, I am placing this matter, my lord.
Yes.
The petitioners are the father-in-law and mother-in-law of the complainant. My lord, they
I'll issue notice, madam.
my-
I'll
I
issue
have
notice.
filed also one IA for
Matrimonial dispute, I'll just examine it. Because you are father-in-law, mother-in-law.
yes, ma'am.
What are the allegations against you?
My lord, the allegation of dowry, my lord, dowry.
Investigation is still going on.
Yes, investigation has not been started,
And then
but my lord, stay of the.
how can I say where is the proceeding?
My lord, as my lord is issuing notice to the opposite parties.
I am only issuing notice because it's a matrimonial dispute. Otherwise, I should not interfere in this matter because investigation is going on. I'll simply issue notice, let us see. Investigation is still going on, I can't pass any order.
Stay.
What will I say?
No,
Can I stay the investigation?
proceeding and the.
Which proceeding?
That city case, my lord.
You say investigation is going on.
City case, my lord, is
Where is that?
city case in my prayer, my lord, city case number 567 of 2024. In IA, I have mentioned, ma'am. In prayer also, I have.
What is, I don't know. You say that investigation is still going on.
And the city case 567.
The matrimonial dispute and allegation against on the father-in-law and his mother.
What is the stage I want to know?
The investigation is there.
What is the city case then? The city case is related to what? 150 of 24.
Taxi has already been filed.
Nothing is there. Is not filed anything. You say investigation is going on.
Sorry.
You are asking for stay of city case. I don't understand what. Charge sheet you say investigation is going on.
Taxi file.
Where is that charge sheet?
Page 10. Page 10. Annex or what?
Page 10.
Yes.
This is the FIR.
That is
Yes,
the-
no, evidence against our husband.
This is
only.
the FIR. This
Yes.
is the FIR.
Out of complaint case, FIR has been registered.
173.
Out of complaint case, sir,
Sorry.
Both of you don't know what is the
Yeah,
fact.
this is-
Simply issue notice and yes, next.
92.
Please, your
You
lordship.
must read and come to the court.
May I please, your lordship?
Yes.
My lord, by the written report presented by the informant, the ISC Sadar PS registered Sadar PS case number 181 on 7th June 2024 for commission of an offence punishable under section 376(2)(n), 417, 294, 323.
It's all right. What are you asking for?
My lord, in this case, I have filed this petition to quash the proceeding, my lord.
Why?
My lord,
Why?
in this case, my lord, the charge sheet has been submitted against the Sarathi Patel, who is the father of the prime accused under section 294, 506 and 34 of the IPC, and
Yes.
against petitioner Samir Patel under section 376(2)(n), 417, 294, 323, 506 and 34 of the IPC, my lord.
Yes.
And my lord, in FIR, the informant alleged that with a false promise of marriage, the petitioner Samir Patel kept physical relationship with the victim for 6 years in different rented house, my lord. And my lord, during investigation, the IO has recorded the 161 statement of the victim in page number 59, my lord. My lord, in 161 statement, the victim has not alleged against the petitioner Samir Patel that he forcibly kept physical relationship without her consent, my lord. And in 164 statement also, my lord, 164 statement is, my lord, at page.
What is the stage now?
My lord, charge sheet has been submitted, and the IO has submitted charge sheet against the petitioner Samir Patel, showing him as absconder, my lord. And NBW has been issued by the order of the landed SDGM Sundargarh. And the case of the Sarathi Patel is, madam, at appearance stage, my lord.
When those two judgments?
Two judgment of
Where is the NBW order?
My lord, NBW order has not been filed, my lord, but in charge sheet, my lord, the IO reflected the same in page number 26, my lord.
Justice Nagaratna, 19. Yes. One more case. Right. When NBW issued on?
My lord, NBW issued on 4th August 2024, my lord.
By SDGM?
By the landed SDGM Sundargarh, my lord.
Right. Petitioner is seeking quashing of the entire criminal case initiated against them, which is arising out of Sadar PS case number 181 of 2024, pending in the court of Sundargarh. For alleged offences punishable under section 376 2N 417, 294, 323, 506 and 34 IBC. The allegation against the petitioners in the FIR is that Paratri. Counsel for the petitioner submits that the charge sheet has been filed against both the accused person, but insofar as the accused person, insofar as the petitioner number 1 is concerned, he was shown to be abscond. Therefore, NBW has been issued by the CJN Sundargarh on 4/8/2024. Counsel for the petitioner has relied upon the judgment of the Honorable Supreme Court in Prashant versus State of entity. He has emphasized on the para 19 of the state judgment, which reads as relying upon the aforesaid judgment, he submits that his case is directly covered by the said judgment. Therefore, no offence punishable under section 376(2) is made out against the petitioner. Before the trial court, I am not inclined, although I am not inclined to entertain this petitioner in this case. However, liberty is granted to the petitioner to move for application before the trial court, raising all the points, seeking discharge Discharge such application is moved to the same shall be considered. This is in the light of the judgment of the Honorable Supreme Court in Prashant Supra. The petitioner number one is directed to appear before the court on or before the 25th of December 2024 and seek remedy as available given under law. Till then, the execution of imbue dated 4/8/2024 by the MP of Andhra Pradesh State. Yes.
Greatly obliged, my lord.
Yes. This was yes.
I may pardon. I may pardon, my lord. Item 62. My senior is here. I've missed the list, my lord. Your lordship may call it some other day, my lord.
Put it in some other day. I'll adjust the list and give it.
Yes. With when?
But he was saying that some entry order is required. That is the reason I kept it.
Your lordship may call it tomorrow. Actually, my lord,
Tomorrow may not be possible, but let him move application before trial court for adjournment.
My lord, here.
See, you can't have.
No, your lordship knows I never seek time.
I understand.
the list.
I understand. Okay, sorted the each week with the
Next week.
next week. 7th, why don't you come on 7th?
Yes.
7th you come Saturday. Oh, he has a problem, some problem.
Actually, I missed the list.
It's all right. All right. Put it 10th. 10th. Okay. Yes.
May I please before a loss? My lord, the order of quashing of cognizance, order of taking cognizance for the alleged offence section 506 and 507. That the affair reveals that there is in hypothetical affair has been given might have wrong steps and evil efforts, but like this, my lord, they have stated. Your lordship will, I pray, my lord, early disposal of the case before the Law and Trial Court.
Early disposal. You are the accused, huh?
My lord, only accused.
Petitioner in the present petition is seeking quashing of the cognizance, the quashing of the order dated 11/8/2023 passed by Lieutenant JMFC M. Rampur in city case number 322 of 2023 arising out of Narla PS case number 161 of 2023, whereby the court below has taken cognizance of offences punishable under section 506 and 507 of IPC. Learned counsel for the petitioner, although has challenged the cognizance order, but he submits that he would not press this petition. However, a direction may be issued to the trial court to dispose of the trial as expeditiously as possible. Expeditiously. The petitioner being an accused in the being an accused has a statutory and constitutional right of speedy trial. Hence, his prayer deserves merit. Accordingly, the trial court is directed to do well to see that the trial is concluded as expeditiously as possible.
The end of
Yes.
94.
Yes, sir.
Lordship, the petition is involved in the criminal case in the year 2017 by the Vigilance Department, but till that the Vigilance is failed to submit the charge sheet against the alleged complaint. The similar circumstances cases will quashed by the Supreme Court. Lordship, kindly glance.
What are you asking here? Quashing of the
Quashing of the criminal procedure in the FIR,
Yes.
though the FIR has been registered against the petitioner, but till that the case was registered till the year 2017. Now we are in 2024. In the meantime, 7 years has been lost, but the department failed to submit the charge sheet. In the similar circumstances, cases also passed by the full court. Lordship.
What is this case?
Instruction receiving long back says that that their the pay particulars, they have sought for pay particulars from the department that has not been obtained, and educational expenditure and a deposit bank from the different concern that has not been obtained. They judgment according.
Binod Bihar Sethi.
Huh?
Binod Bihar Sethi.
Tab.
Binod Bihar Sethi.
Vigilance case.
Vigilance case.
देखिए
Vigilance case नहीं कि
No, no, it is different fire. It was registered in 2006
Clerkship.
and 2012 it is,
Clerkship.
22 it is.
Clerkship. So Clerkship in the meantime,
Take
clerkship.
instruction, what is the change? Issue notice to Department of Vigilance and Mr. Manana accept notice and seeks time to get instruction regarding the status of the investigation.
One thing I may have, since it's a DA case, the petitioner may be directed to produce all the relevant documents. Whatever.
7 वर्ष हेलानी
I don't know, the charge sheet, if he already filed, then there is no point. He is not seeking on merits. If you would have
on the ground of delay.
sought in merit, then I would have asked you to
On the
ask him.
ground of delay.
Delay only. So therefore, that can't be, so issue notice only. Yes.
95.
My lord, may I please order?
Yes.
Is the case to cause the proceeding pending under section 212 of debates in Jatpur Court, Jatpur Jatpur. And so far, my lord, annexure 1 is concerned, that is the complaint itself. There is no allegation against the OP number 2 to 4. They are the father-in-law, the sister-in-law, except at page 3, at page 13 of the annexure 1 demanding of 3 lakhs. And so far, case is concerned, my lord. The case was filed April only. The husband be resigned from the service as you were working in the software engineer somewhere in Bombay. And subsequent, when was the restraint, the case was not filed. And where, my lord, the OP is has a handsome incomes earning as a government teachers in the Jajpur itself. Absolutely no allegation against the OP number 1 to 4, my lord. Sister-in-law, father-in-law, except the demanding of children when she was there. At
Why don't you tell all these things to the trial court? Why have you straight away come to this court? You have to file your show cause and tell that there is nothing against me, no relief is sought against me. Why should I be prosecuted? Remove application, I'll give that limit.
But they are terrorizing only on the ground that let the husband be revenged with the leaving the parents with her at Jajpur.
Whatever, I can't go into all these things, whatever the allegations he has made. But notice has been issued to you by the court. You have to file a reply. The trial court will decide.
After they filed the Sokos also there, my lord.
You already filed?
Already filed, my lord.
No, so let the trial court decide it. And you have made all the husband and in-laws, everybody is party here. I can't examine the merits of the case qua every petitioner.
Only with reference to the petition itself, the complaint petition itself, where the lordship will find actually no allegations against the in-laws.
There are some allegations against the husband. There are some allegations against the mother-in-law.
Against the husband, there when the child was born, he started to torture her. That's the only allegation.
No, you should have selected 1 or 2 petitioners and filed. Now you have made all the petitioners a party. All the respondents a party.
They are the parties in the law, madam.
Petitioner is seeking quashing of the, and the petitioners are seeking quashing of the entire criminal complaint arising out of a complaint under section 12 of DV Act initiated by opposite party number 2 on various grounds. The counsel for the petitioner submits that insofar as complaint case is not filed, nothing is filed. What to do? In the present petition, except the proceeding before the court below, 3 proceedings before the court below, 1, 2, 3, 3 proceedings before the court below, no other document is included. Legal counsel for the petitioner submits that there is no allegation made against the present petitioner in the complaint case and as against the as against the
Between 1 to 4.
petitioner, as against the mother-in-law, father-in-law, there is no specific relief is also sought by the opposite party, However, since in the absence of the copy of the complaint filed by the petitioner in the opposite petition, one. However, at this stage, I'm not inclined to dwell upon the merits of the complaint initiated by the opposite party under section 12 of DB8. Therefore, I'm not inclined to entertain this petition. However, liberty is granted to the petitioner to raise all the points before the court below, and the court below is directed to deal with the contention raised by the petitioner and the pass a specific order. With this subdivision. Yes. Yes. Next. Yes.
May I please, your lordship?
96? Yes.
My lord, I have filed this application, my lord, for quashing of the affair, but I am not pressing it on merit. My lord, my anticipatory bail applications has already been rejected. I am implicated in this case on the basis of the co-accused confession, and co-accused already released on bail. I pray before your lordship.
Although prayed for quashing of the entire FIR registered against him in the present petition. However, at the outset, he submits that he will not press the petition, rather prefer to appear before the court below and seek remedy available to him under law. At the same time, he submits that the co-accused, on the basis of whose confession he has been implicated in the present case, has already been enlarged. Who has enlarged?
That the co-accused persons find out.
Which
I get Pratik Ball.
Enlarged.
The certified
Write down the name of the co-accused, Pratik Bal. On whose confession statement petitioner is implicated in the present case, has already been admitted to bail by the court below by its order dated 1/2/2024. Therefore, he submits that he is entitled to the parity with him. However, since his anticipatory bail application has already been rejected by this court, he submits that his client would appear before the court below on or before 25th of December and move appropriate application before the court below. On all the grounds, including the ground of parity. Such application is moved and submitted.
97. 1 week time for time instruction. 1 week time for instruction.
What is this case? Let us see.
The Conjugal branch and the Monopuram finance asset are the stolen property received.
Lordship, the present petitioner challenges the Annexure 5. Annexure 5 is the IO has issued this notice and treating this as summons under section 94 BNSS, because after the investigation is over or while the investigation is going on, the IO has observed that the ornaments that has been kept by this Manappuram branch is a stolen because an FIR has been lodged regarding those stolen ornaments.
Okay.
The compromise is going on.
94 of BNSS.
Your Lordship.
BNSS. Where is that notice?
At page 23, Your Lordship.
23.
The second para is.
Remember, the investigation proves that all the ornament equals by the accused are stolen property. Interception shown show. Who are you?
I am the petitioner. He's the
No.
branch manager, Lord.
The branch manager. What is wrong in it? Only notice has been issued to you. Go and produce. Madam, petitioner is petitioner is not the accused.
Right.
Who is the accused?
Lord, those certain those power of attorney, your lordship, those copy of certificate. These are the company. This is a company. And
Who all are the accused? I am asking. Petitioner is the branch manager.
at page 4, para 3, your lordship, the petitioner has been advancing loan money to its customers by accepting the pledge of the gold ornaments through its branches. The authorization has given to the area head.
Branch manager. Petitioner is the branch manager of the Manapuram Asset Finance Limited. Finance Limited. Or next paragraph. The petitioner is seeking washing up for the notice dated 17/9/2024 issued by the police under section 94 of BNSS 2023, whereby the petitioner was summoned to produce the seized ornament in PS case number 433 of 2024. Since the petitioner has been maybe since the police has only issued notice to the petitioner under section 94 of VNSS, there is no prejudicial order exists against him, hence no interference is called for. The petition is dismissed. Yes. Yes.
98. Question of affair, but fact remains that some of the co-acquit persons who have been named in the affair, they have been arrested and granted bail by the learned court below. So for the present petition concern, since his name does not found place in the affair, but subsequently
notice following upon the petitioner to following upon the petition agenda. Second paragraph notice. Next paragraph, notice, second paragraph. Second paragraph of notice. Yes.
307 is the 307 is the
Item 97 has been disposed
of.
307 is the alleged offense matter. And two persons who are main assailants who have assaulted matter, they have been arrested and granted bail by the learned court below. So for the present petition concerned, on the basis of confessional statement, subsequently absconded charge sheet has been submitted against him.
Against you.
Mine.
Yes.
And may it remain on surrendering, I may be granted bail because earlier, since my name does not found place, my
in the FIR your name was not there. And in the charge sheet your name came because the co-accused has
yes. I was present at this spot along with them. That is the allegation.
And your anticipated bail rejected.
Rejected on the ground that my name does not found place. And if the case
where is that order?
That order is also.
So now you are shown absconded.
Last three lines of the first order.
Where does it say that you are not?
First three line, your lordship, last three line of part three, lordship, if the so arises.
Everything is given to you. What is the problem?
If since my name does not congress earlier, bail just
Now you can go now.
on that observation also may dispose of
No,
current
the court has already given observation, parity and everything.
but
The court has said that see, this application stands disposed of with the observation that when the occasion would so arise. Now occasion has arisen for the later court in session for the case, consider the matter relating to grant of regular bail of the petitioner, and the same shall be considered on its merit, further taking into the factum that release of co-accused persons so and so. Now you have to obtain for regular bail only.
yes, that is why I am paying my law to be disposed of with that of the
Petitioner is seeking quashing of the FIR. Jaipur PS case number 70 of 2020, 2022. No, 2022. The counsel for the petitioner submits that in the FIR, the petitioner was not aided as an accused. However, on the basis of the confessional statement of the co-accused, he has been implicated as an accused in the charge sheet filed on 18/5/2022. The petitioner has been absconding since then. At the stage of investigation, while the investigation was going on, petitioner had approached this court by filing ABPL number 5770 of 2022. The bail application was disposed of because at that point in time, the petitioner was not even aided as an accused. Relevant would be to reproduce the relevant part of the order dated 26/10/2022 passed by this court in ABPL number 5770 of 2022. Para 4. Counsel for the petitioner submits that he would not press the present petition, rather the petitioner would surrender before the court below on or before 25th of December 2025 and avail the benefit of the observation made by the coordinated bench of this court by the order dated 26 yes, as mentioned, as reproduced above. With this observation, the petition is disposed of. Yes.
99, my lord, 99 not press this matter.
Not press. 99 not press.
100.
Yes.
I've filed an affidavit regarding the status of the victim. There is that flag B, my lord.
Status of who?
The victim, my lord, the informant.
Yes.
Now she already got married, my lord, to some other person and now staying with.
What are you asking, by the way?
I have quashing of affair on the ground that my lord, the 376 and other offense not made out because the victim is 22 years at the time of occurrence. And FIR has been lodged at annexure 1, page 9.
The victim 22 years, but POXO is involved.
POXO is there. So Lordship has directed him to file an affidavit because if the notice will go to the victim, his marital status.
I'll issue notice, huh?
Yes.
Issue notice.
Lordship, the 161 statement, but states otherwise.
Let us see issue notice.
Yes,
He says 22 years.
Yes.
If anything can be done, why not?
Lordship.
Settlement has taken place.
Yes.
Yes. Issue notice.
101.
I filed a miscase for not to take in
Yes,
court.
application, huh? Before trial.
When the the case is going on for investigation, the charge sheet has not been filed.
Other than what do you want?
Not taking coercive action against the petitioner till late.
No coercive action. I don't know what is the stage and all.
No,
POXO is there. I can't even do that.
Till her appearance now, the you will arrested.
POXO is there. I don't know. Where is your you had approached this court?
No, never have approached.
Then how can I, in 482, I can give that?
Till her appearance, at least, if matters are sorted out, then
That's
Now
right.
she
but,
now she had already got married.
Show me any document
My lord.
which would give her age.
That I have
when-
given that, my lord. That is that the statement of the victim at my lord. Annex 2. Yes, my lord.
You have not filed. Charge sheet has been not filed.
Not filed.
Investigation is going on.
Going on.
Where does she say?
Yes, my lord.
Morna Suvarna Sahu. Where does she say that I'm 22 years?
That at the top of the my lord, the 161 complaint, Suvarna Sahu, 22 years, my lord. In fact,
Today she is 22 years.
at
But the
time,
offense had taken place
she goes to,
2015.
that at the I was 15, she had.
For a PDS, they withdrew money. But in the May 19, the informant alleged that the petitioner withdrew 33 lakh, 12,000, 9,000. Thereafter, on 20th lodges affair. On same allegation, petitioner also deposited the same amount on the 27th. The humble prayer of the petitioner, the order of the cognizance taken a land court below, and the matter is in between settled between the joint account and they are in the same office. For that reason, I pray before the annexer to my lord. Order of cognizance.
What are the allegations against you?
Allegation that my lord, without his allegation, without his consent, he withdraws through RTGS 33,000, 12,000, 12,000, and 9,000.
You have withdrawn
Yes.
from his account.
No, joint account. That's the PDF.
I'll issue notice if it's joint account. Issue notice. Opposite party no. Yes. We'll see. Yes. Next. One. Let us see. Bring him. We'll see. Because the joint account without taking consent, you have withdrawn the money and all. Let us see. We'll see.
Signature has been.
Signature has been forged. We'll see. Yes.
Please, your lordship.
That is the expansion of excess minds.
That
proposal was for that day.
He changed his mind now.
No, it was adjourned because they wanted to verify the genuineness of annexure 2.
There is a problem that the division bench has said that.
Exactly.
Have you given the copy to him? Huh? Just read it and I'll next solo up there. Just read it, sir. We'll see. Huh? 16. Yes.
103. I may please your lordship. My lord, petitioner number 1.
And that option also keep open. That option, the one which you have said.
No, if the letter of the SJTA consultant is genuine, why should that also remain?
That part you can agitate in the right form or right stage.
It is not. I cannot do it because they will not ask me anything or they will not take cognizance of whatever I produce. But since they are investigating, should they not investigate that aspect?
I'll direct them to investigate.
The lordship can say that, let them investigate into
that part you investigate, and insofar as that money part is concerned, retain 3 crore rupees and release everything. As simple as that. Why unnecessary keeping it pending?
No, let it come on the 16th. Let them take instructions.
So there are two things. One is insofar as whatever you are raising here,
yes,
the IO has to take into consideration in accordance with law and deal with that. This is one aspect. Second aspect is the money part, whatever the money part you are saying, 3 crore rupees will be retained and the rest of the amount will be released.
What I submit is this. The IO may take instructions whether the letter of this at annexure 2 is genuine.
He will verify it and rightly will.
Let him
I'll dispose it up. I'll dispose it up. Give the instruction and do those two things. I'll do it and dispose it up. I'll give a direction to the IO to verify the authenticity of this thing and take it to consideration in accordance with law. And 3 crore rupees will be retained and rest of the.
No, Lord, that amount your lordship may not say. About that retention, I'll be not in a position to.
Last time you said that.
That I said because of that occasion.
No, I have taken instruction.
Then 16, you seek an
Let it
instruction.
be on this.
This is the proposition if happens. Okay.
Let it be on
Yes,
this.
16, okay.
Under three, my lord, the petitioner number one is the legal married husband of the opposite party. Their marriage was dissolved in CP number 277 of 2021 on 15th May 2023 before the judge, family court Puri. My lord, there was a compromise between the parties. Annexure 4 is the compromise petition. And kindly have a glance page 31 of Annexure 3. The opposite party in her deposition deposed that she will withdraw all the criminal proceedings against the petitioners. My lord, since 2023, 15th May, she has not cooperating the honorable court. She has not come to the court till date. As per instruction, she is already married.
He is already?
Married, my lord.
Oh, you take out notice, let us see, issue notice. Yes, next.
104.
Petitioner before my lord is a practicing lawyer here at Kotak. And he was summoned to appear for commission of offences on section 294, 324, 506. There is section 34 of the Indian Penal Code. He filed a petition on section 205 CRPC, and which was rejected by the court below by the annexure 1.
Yes.
Since she is a practicing here and the far away place, there is no dispute in the identity. The court should have allowed that 205 petition instead of rejecting.
Yes. He's a lawyer practicing.
My lord, here annexure 5
Annexure 5 will be given the document.
and practicing here at Kotak.
No. Enrollment doesn't mean that High Court Bar Association. He's really practicing or simply a member?
No. Practicing.
As and when required, he should be exempted, that's all. As and required, he should go and appear. Not a blanket exemption. As and when required, you should go.
As and when required, he should.
And the rest of the time, you should be represented through counsel.
The lower court has, in fact, rejected the petition stating this very fact. At page
Where is
8,
that?
Page 8 and 9.
8.
Page 8.
Relevant part, read.
The third paragraph. Has failed to produce any scrap of paper confirming that the accused petitioner is a practicing advocate.
Wait, where are you reading?
What's annexure 1, page 8.
Page 8, which paragraph?
Third paragraph, your lord.
Yes. It is after going through the complaint. There is counsel for the petitioner complaint. Which part I don't get it? Which paragraph?
Lordship, first, second, third.
Read it, the beginning of the paragraph.
The learned counsel on behalf of the complainant has raised formal objection by stating that the petitioner has failed to produce any scrap of paper.
You have not produced those things.
Confirming that the accused.
The aberrament was made, supported by affidavit.
But you have not produced that document.
Yes, if that was so required, it can be asked to produce. Matter could have been.
Where is the operating part of the order? The accused person collectively.
Operate page 9. जो decision टाको rely करी the court will rejected that petition has been allowed. How did the case was relied upon?
Where is this case going on?
This is going on at Gramnad, Sana community.
Ganjam.
Yes, sir.
Oh, it is only 2.5 hours journey.
The operating portion is the second last paragraph at page 9, your lord.
I'll see what I'll do is, as and when required, he'll go, and the rest of the time he will appear through counsel.
Yes, sir.
Why are you unnecessary?
Lordship.
Appearance by court
Petition is agreed by the order dated 22/4
Fundamentally
24, whereby the application under section 205 CRPC has been rejected. The petitioner is an accused in PS case number and the complaint case number, which is that ICC case number. 1CC case number 1 of 2020.
for alleged commission of offences punishable under section 294, 324, 506 and 34 IPC. Mr. Mahapatra, senior counsel appearing for the petitioner, submits that the petitioner is a practicing law in High Court. And he has also filed the identity card issued by High Court Bar Association to substantiate that point. He submits that the application of the petitioner has been rejected only on the ground that the petitioner could not establish that he is a practicing lawyer of this court. This finding is contrary to the document he has relied upon. Be that as it may, since the petitioner is a practicing lawyer, I am inclined to entertain this petition and allow the application under 205 CRPC moved by the petitioner, subject to the condition that the petitioner shall appear before the court as and when his physical appearance is sought for. And in the rest of the proceeding, he should participate through counsel by moving application under section 370 CRPC. With this observation, the petition is disposed. Yes.
105. May I please, Your Worship? Here the wife doctor is before your worship. That's a proceeding under section 12 of the Protection of Women from Domestic Violence Act 2005.
You are the
Wife
husband.
and daughter.
Huh?
Wife and daughter. You have.
Wife and daughter.
Yes.
And what are
section 12 application was allowed, giving maintenance of 4,000, 2,000, 4,000 to the wife, 2,000 to the daughter. Execution proceeding was initiated. Though the husband didn't pay the money, warrant was issued, NBW was issued. The husband came before Lordship. Your Lordship passed the order.
Where is that?
Your Lordship may kindly see is 70.
Yes.
Your Lordship has passed.
Yes.
Para 3 and 4, Your Lordship may Lord and counsel for the petitioners. My Lord, the husband and on instruction from his clients undertake that his client should be appearing before the court.
Yes, 30th June.
30th, and seek appropriate remedy available from them under law. Taking into consideration the above facts and submission at the bar, the execution of the order related such and such.
He stayed subject to his appearing.
My Lord. Your Lordship may kindly see the order passed by the trial court.
Where is that?
28/6/2024. Page 24, Your Lordship.
20?
Yes, 24.
Okay.
What has happened? Bail application was filed and it was allowed, and the execution proceeding was stayed until further order. Madam, I fail to understand what the.
Where is bail?
Yeah, exactly. What is the concept of bail whenever domestic violence?
Issue notice.
It is the execution proceeding.
In the execution proceeding, where is the question of bail and all?
And the wife will.
I said that go and appear and resort to the remedy.
Right. But bail application was allowed and the execution proceeding was stayed until further orders.
Satisfied and comply the order earlier passed by me. Okay, where is that order? MP order.
Order base 24, Your Lordship.
24. Yes.
Order
28/6/2024. On the
28/6/2024.
strength of the advance petition,
The record is stayed until further order. Thereafter, bail is granted.
It is not also, hence considering the order, the record is stayed until further orders.
And thereafter, bail was granted. Later. Then thereafter, Lordship may kindly come to.
I'll issue just simply issue notice, let us see. We'll sort it out here.
But issue notice.
Instead of disposing of, let us. I'll just issue.
What has happened? Your Lordship will, if your Lordship will issue notice, your Lordship may say that the husband has to pay the money. Otherwise, how I will leave?
No, subject to paying. Yeah.
Or you also say that the operation of this order be stayed.
Where is that interim direction for paying maintenance?
Maintenance is.
Where is that order?
Order was not, I have stated in para 3. Para 3, Lordship may kindly see page.
Para 3 of your petition?
Yes, Your Lordship.
And issue notice to opposite party number, opposite party, opposite party, parties.
The parties 2, 3, 4.
Why 2, 3, 4? Who are they?
But they are the petitioners in the criminal miss case. Before lordships. One is husband and other is my lord the family members.
No. Acha. Oh, okay. They are different. Opposite parties.
So opposite party. Who is the husband?
It can't be stayed. There is no question of stay.
Stay of the operation of this order, your lordship.
The operation of the impugn order dated 28/6/2024, passed by the JMFC Konark in execution case number 54 of 2022 is stayed. And what I'll say is I'll revive the execution petition and let it go on its own merit.
Yes, yes. That also
Why should I keep it pending?
Yes, your lord. That will also suffice.
Bail or no bail, how does it make difference?
No, what will happen if my execution proceeding will go on? So ultimately, my lord, NBW will be there. Existence of NBW will be there because
I have cancelled for that particular day.
But once bail has been granted, means the husband will not cooperate in the execution proceeding and will not pay the money.
Okay, right on. Petition is agreed by the order dated 26/8/2024, passed by Leonard JMFC Konark in execution number 54 of 2022, whereby the execution proceeding has been stayed and the petitioner has been enlarged on bail. Earlier, the opposite parties had opposite party 2 to 5, 2 to 4,
2 to 5,
2 to 5. Approached this court by moving
2
to 4 by moving CRLMC number 1965 of 2024, seeking cancellation of NBW issued against them by order dated 29/8/2024 in the execution proceeding. This court, by order dated 21/5/2024, has passed the following order, para 4 of that order. Pursuant to the aforementioned order, the opposite party number 2 to 4 may appear before the court below and moved an application for enlarging them on bail, enlarging the bail. The trial court, while allowing the bail, allowing the application of the opposite party number 2 and 4, admitted them on bail, and at the same time stayed the execution proceeding initiated by the petitioner against the opposite party number 2 and 3 for execution of the maintenance order dated maintenance order dated
2/9/2022.
2/9/2022, passed by the JMFC, passed by JMFC Koral in
my lord, domestic violence miss case number 16 of 2020.
Domestic violence
miss case number 16 of 2020.
2020.
And the execution proceeding is my lord 54 of 2020.
Mr. Mahapatra and counsel for the petitioner submits that this court had cancelled the NBW issued by the execution court dated 29/8/2023 and allowed the petitioner to appear before the court and participate in the execution proceeding. However, the trial court, by misconstruing the order of this court, has not only enlarged the opposite party number 2 to 4 on bail, but also stayed the entire proceeding, entire execution proceeding. As a result of which, the present petitioners are deprived from getting the maintenance, monthly compensation as has been directed by the court below.
Compensation also. Compensation of 50,000.
And maintenance and compensation as has been directed by the court below. Hence, he seeks indulgence. I have perused the impugn order and the order passed by this court. I am satisfied that the impugn order passed by the trial court is devoid of merit. Hence, the same is set aside. Set aside. The opposite party number 2 to 4 are directed to participate in the execution proceeding. And the trial court is directed to deal with the execution proceeding in accordance with the law. With this observation, the petition is disposed of. I have revived the
absolutely.
Let them do what
Absolutely. Absolutely.
Yes.
I have filed, my lord, earlier this present petition before your lordship. My lord, kind of a glance to this, the page 11. I have annexed again, page 11 of my brief.
What are you asking for?
My lord, earlier, my lord, this present petitioner filed the application before this honorable court to release of his cash amount which has already been deposited, my lord, by the order of the Lawrence court below. Because that the case that the main accused person, she has already been acquitted. And this present petitioner neither is an accused in that case, nor she has any nexus in that case, my lord.
Yes.
Till today, my lord, the charge sheet has not been filed against the present petitioners or her involvement. Although it is a case of the year 2018.
What is it agreed by?
I agree with my lord that I have filed this application, my lord.
That is an application.
For it before this honorable court, and this honorable court was pleased to direct page 11, my lord, the order portion, my lord. Taking into consideration the aforementioned fact, I am of the considered view that the petitioner may move fresh application before the court below for release of the cash security of rupees 5,76,766, and in such application is moved, the same shall be considered. I have filed the application before the Lawrence court below as per the direction of
Rejected
rejected in the ground. That is the rejection order, my lord, on the ground that investigation is open. That last portion, my lord, page 15, investigation is open. So, my lord, my humble submission that it is a case of the year 2018. This present petitioner before your lordship feel that she is not the accused in this case. Rather, my lord, other co-accused.
I issue notice, Lord.
Other co-accused.
Just check it up.
Yes, sir.
What he says is earlier he came to this court. This court has said that if the release of that amount, 5 lakhs or something,
Within a matter of 15 days.
should be considered on its own merit once he move an application. He moved the application, now it is rejected. He says that he is not an accused. Why his money is retained? That is what he says. But the problem is, except that impugn order, you have not filed anything. You are telling all the stories without document.
So, environment
Environment, where is that order? Acquittal order and all. To file all these things, at least they will take instruction. On the basis of environment and pleading, in a criminal case, I'll allow.
Impugn order acquittal.
No, you file it. I issue notice and file it. I issue notice, which takes accept notice. In the meantime, petitioner seeks to file additional document to substantiate the case. Lease the matter after 2 weeks. Yes.
My lord, I have a particular date.
The date will be. Yes. Before I file those documents, I can dispose it of immediately.
Before vacation.
You have a good case. It can be allowed. Yes. Before vacation only. Give it before vacation. Good case. Yes.
Your Lordship, my senior is in Mishra District and Sessions Court. I honestly improper Passover. She'll be here.
Okay.
Much obliged.
Yes.
108. May it please, Your Lordship. 108, my lord, here, Your Lordship, the FIR registered in the year 2010 and charge sheet submitted in the year 2011. Cognizance taken, charge has been framed, my lord. Since now, no witnesses is turning for the trial, Your Lordship.
Who are you?
I am the accused in Ostrang PS case. 2 petitioners are there.
So what do you want in this petition?
My lord, I am challenging the proceeding because, my lord, I am protected with the government of Honorable Supreme Court in Satyendra Kumar until where Honorable Supreme Court stated, whatever may be the nature of the offense, a prolonged trial, appeal or a revision against an accused or a convict under custody or incarceration would be violative of Article 21, right to a fair and speedy trial in the facet of Article 21 Indian Constitution, Your Lordship. In this case,
I'll speed up your trial.
My lord, if Your Lordship will speed up the trial, no one is appearing, my lord. the learned court below issuing some summons to every complainant and witnesses.
You are in custody.
No, my lord, I am not in custody. Your lordship may kindly call a status report from the learned court below and issue notice to the complainant. That is only, stay is not required, my lord.
The offenses.
Opposite party number 2. Complainant.
What is the what is the for any other that is filed on
2011.
This is not T20 or 1 year things are moving.
All order sheet I have appended with the CRLMC, my lord. In each date, my lord, the learned court below issue notice to the complainant and other witnesses. No one is appearing.
Yes. I'll see. What I want to do is we can expedite the trial. It will be whether it will get into the or not. And ask for a little bit of but the petition is 2% of the water quality in 9/2011. Ask for a little bit in India, about 500 and just verify by the but you have collected of the predicted the client is not yet confirmed with them. Therefore, the police submits that is right into one of the constitutional violated according to the 6 single human scope for watching of the watching the people. We should move to
Grateful, my lord.
Apart from this, provided by the 25/1/2024 allowed the civil proceeding initiated by the petitioner number 1 and directed the opposite party number 2 to resume the conjugal life with the petitioner number 1. Despite the said order, the petitioner opposite party number 2 has not comply and despite this has not joined the company of petitioner number 1. Petitioners are seeking passing up for the criminal prosecution initiated by the opposite party number 2 in the present proceeding. Issue notice to opposite party number 2. Meanwhile, the proceeding before the which court?
JMFC Banapur, my lord.
JMC Banapur arising out of the FIR Banapur PS case number 143 for 2018 with staged till next date of it. In the meantime, since the dispute is arising out of a matrimonial discourse and there is a judgment for the family court, Banapur, family court?
Yes, my lord.
Family court for Banapur, allowing the petition under section 9 of Hindu Marriage Act. I feel it appropriate to refer the parties to mediation cell of which district? High Court mediation.
Yes, my lord. It would be better.
Mediation center, High Court mediation cell, and the coordinator is directed to fix a date and intimate the same to the parties to participate in the mediation for exploring the possibility of settlement. Awaiting the mediation report, release the matter. I have stayed the proceeding. I have sent it to mediation. Settle it out because there is a order.
Yes, ma'am.
It can be. Yes.
Deployed.
Yes.
Yeah, please, Lord.
Yes, sir.
Challenging the criminal proceeding initiated under the Negotiable Instruments Act, my lord.
Yes.
My lord, may kindly turn to page 18. My lord, the proceeding has been challenged on 2 grounds. One is notice which is mandatory to be issued to the signatories. Only notice has been issued to one signatory, that is that too in its individual capacity. Number 2, the company on whose behalf the checks were issued has not been added as.
Show me that. Come to the complaint. Come to the complaint.
Page 18.
18
yes. To 23 are the checks.
Check is the Krishna Skyscraper director.
Your Lordship will observe there are 2 signatories.
2 signatories. And yes.
Complaint has been filed only against 1.
Against
notice,
1.
Notice has been issued against 1 to 1. Your Lordship will kindly see at page 30.
30.
30.
30. Yes.
Notice has been issued in the individual capacity, not as a director.
Okay. Right on. Petitioner is seeking quashing. Petitioner is seeking quashing up for the 1CC case number 4125 of 2014 pending in the court of STGM, Bhubaneswar, initiated by the opposite party for alleged commission of offence under 138 NIA. The learned counsel for the petitioner has taken me to the annexure for the petition to show the annexure of the petitioner, which reveals that the check has been issued. Subject check was issued by subject checks were issued by the by 2 directors. 2 directors on behalf of one Krishna Skyscraper Limited. Krishna Skyscraper Limited. The present petitioner is one of the directors of the said company. Notice has been issued under section 138 NIA to the present petitioner in his personal capacity. Therefore, the learned counsel for the petitioner submits that the opposite party is prosecuting the present petitioner with present petitioner alone without impleading the company or the other director who has signed the checks. Therefore, the entire criminal prosecution initiated against him is vitiated. Issue notice to opposite party written also the proceeding before the court of SDJ Bhubaneswar in ICC case number 4125 of 2014 date in the next date appearing. Yes.
What obliged, madam?
Yes.
That would be one CC, madam.
One CC case, yeah, one CC. Yes.
May I please, Your Lordship? This is almost akin to the previous case conducted by my friend Mr. Lal. Your Lordship will kindly turn to page 14. The check was issued by the petitioner as managing director of the company. Your Lordship may kindly see the check.
14?
Page 14 of the brief.
Yes.
The check, which is subject matter of the 138 proceeding, was issued by the petitioner as the managing director of the company, Your Lordship.
Engineering Geotech Private Limited.
Madam.
You are the director. You are the managing director.
Yes, madam. The notice, my lord, has been issued in my personal capacity at page 13.
30?
Page 13, 1-3.
3.
To Purna Chandra Panda, not to the company or the managing director. Prosecution is launched. Complaint case, Your Lordship will kindly turn to page 9.
90?
Page 9.
9.
Yes.
Okay.
Prosecution is launched against me in my individual capacity. No company, nothing.
Right. Petitioner is seeking quashing of the in order dated 5/9/2000. What are these orders? In order?
Oh, 5/9 is the order taking cognizance. I appeared and filed that I should be exonerated because this cannot run in view of the Supreme Court decision. That has been rejected, saying that no, it can run.
Yes. Petitioner is agreed by the order dated 5/9/2022 and 20th 6th 20 passed by the learned JMFC. JMFC number 242 of 2022. By order dated 5/9/2022, the court below has taken cognizance of offence under section 138 NI Act against the petitioner. Whereas by the order dated 26 2024, the trial court has rejected the application moved by the petitioner for dropping the criminal prosecution against him on the ground that in the absence of the company on behalf of which the check was issued, the prosecution is vitiated. Mr. H.K. Mishra, learned counsel for the senior counsel appearing for the petitioner, submits that the check was issued by the present petitioner being the managing director of Messrs. Sri Engineering Geotech Private Limited. Subject check. However, the notice was issued to the petitioner under section 138 NI Act by the opposite party in his personal capacity, and subsequent thereto, the ICC case has been instituted against the petitioner alone without impleading the company, company on whose behalf the check was issued. Issue notice to opposite party, written and so on. So, in the meantime, the proceeding before the court of JMFC Jajpur in ICC case number 242 for 2022 state. Yes.
That is Jajpur Road, Your Lordship.
Jajpur Road, huh? Yes.
Yes. Obliged.
Yes.
112. May I please, in this case, petitioner challenged the order of cognizance by Janitor 1. Petitioner number 1 is a brother, petitioner 2 is wife, ଆଉ ଇନଫର୍ମାଟିଭ ତାଙ୍କ ଆଉ ଗୋଟେ ଭାଇର ଭାଉଜ ଡ୍ୟୁ ଟୁ ଫ୍ୟାମିଲି ପ୍ଲାନ୍ କିଛି ନାହିଁ ଖାଲି ଫଲ୍ସ ଲଜ୍ এটা নোটিশ গলা পরে কম্প্রোমাইজ হয়ে যাবে
Three cases are
ফ্যামিলি কল ঠিক আছে
three cases. One FIR
One
was
family.
one FIR was registered on
after expired of a father
What are the allegations?
allegation.
Who has done what to whom? Who has done what to whom?
Sister-in-law was done with a brother-in-law. Sister was the FIR on behalf of the brother-in-law between the land dispute between two brothers.
I'll issue notice then. All the three matters I am sending to mediation. I'll stay the proceeding and stay. Right now. Let them settle. Right now. 112, 13 and 14. In all the aforementioned three petitions, the dispute is arising out of the parties are related. All are the parties in the all the aforementioned three petitions are related, belongs to the same family. The dispute appears to have been arising out of the land distribution. It appears to be a land dispute. Cross case has been filed against the parties against each other. Issue notice to the opposite parties. Written so and so. Since the parties are related and the allegations are not serious in nature, I'm of the considered view that the parties can be relegated to the High Court Mediation Center for the purpose of exploring a possibility of settlement. The coordinator of the High Court Mediation Center is directed to issue notice to the parties and stakeholders and explore the possibility of settlement. Awaiting the mediation report, list all these three matters on certain day. Meanwhile, proceeding arising all are at what stage? In
further proceeding over there.
Yes.
Further proceeding.
Which proceeding? That's what I'm asking. Three proceedings are different proceedings.
Different three cases.
Three cases. Proceeding before so and so.
I
good paragraph. Yes.
115.
Maybe pass over, my lord.
Pass over. Yes.
116. Please, your lordship.
Petitioner has filed its current CRLMC with an object to quash the criminal proceeding by GR case number 807 of 2024.
Yes.
My lords, the prosecution story in a nutshell is that on 4/11/2024, the petitioner physically as well as verbally abused the informant's daughter in the informant's institute. As an offspring of which, on 5/11/2024, an FIR was registered. But my lords, I would like to suggest that the entire prosecution story is nothing but a fallacy. Because on 6/11/2024, at the time of availing bail, the informant suo motu came and suggested to the learned adjudicating authority that he misconstrued the scenario as an offspring of which the FIR was registered, and he also submitted and compromised affidavit, which is at my lords annexure number page number 15, annexure 2.
Yes.
My lords, in that compromise of affidavit, it has been clearly mentioned that he misconstrued the scenario as an offspring of which.
Yes. What are the offences?
My lords, the offences are under section 126 clause 2, 74, 70.
I'll issue notice because there is a settlement. Issue notice to opposite party. Number 2, written agreement so and so. Okay. Counsel for the petition submits that the parties have settled that dispute, and the opposite party number 2 has filed a compromise affidavit before the courts below on 6/11/2024. Relying upon the said compromising affidavit, he seeks indulgence of this court and for quashing the entire criminal prosecution. Issue notice to opposite party number 2, written order so and so. In the meantime, proceedings before the trial court is arising out of GR case number 807 of 2024, pending before the court of who is JMFC.
JMFC City.
Yes, state. Yes.
170.
Yes.
117 my losses so like a HM matter. The bail was granted on 26/9/2012 and NBW was issued on 25/9/2024.
24. How many?
Wait, please.
500 is. Yes.
My lord, the opposite parties are the parties are present. Present today, my lords. They've mutually compromised the matters. They do not want
Whatever I have cancelled the NBW, you go and do whatever. Appear before the court. Yes, next.
180.
My lordship, NBW was issued on 23rd/3/2023.
Yes.
The case of standard that not has been.
They were on bail. They were on bail. There are 2 petitioners, 500 each. Yes.
I mean, pardon, my lords.
ये जो High Court को कर रहे हो ना, just see if the district court the bar association करने की कोशिश करो.
Pardon, my lords.
Yes, madam.
My lords may also observe that in view of the settlement, they may be permitted to move the learned court below.
Item 117.
117 in 170 show कर दो. At this stage, the learned counsel for the petitioner, learned counsel for petitioner and opposite learned counsel for the opposite party who appears on advance notice conjointly submits that the parties have settled their dispute. It is open to them to move to the move before the trial court for trial court in appropriate application in that regard as well. Yes.
190.
Yes. 119, my lords. May I be allowed to submit? The petitioner before my lords is a labor class worker, my lords. He was granted bail in the year 2010. In 2017, due to some miscommunication from his advocate, he could not appear before the learned court below.
Pay 1,000. Yes.
Lords, may kindly bring it down to 5 a labor class worker, my lords.
Sonpur Bar Association. Sonpur. Yeah, 500.
500, my lords. May be allowed to go on previous bail, my lords.
Huh?
May be allowed to go on.
No, don't cross the limit.
20.
You to the remedy, already you are on bail.
He was on bail for 7 years.
Next.
20.
May I please, your lordship? My lord, I am the VC, your lordship.
Yes, madam.
My lord, I am in the VC. My lord, it is the
Yes,
Belgium matter.
I can see you.
Pleasure, your lordship.
Yes.
My lord, it is a Belgium matter and NBW issue is in the AK/12/2023 and a bail release of 11/5/2022, my lord.
11/5/2020. There was granted an issued on 1/12/2020.
500. Yes. Yes.
121.
121, may please your lordship. On November 18th, your lordship had directed to gain the criminal antecedents of the present petitioner. I pray for the regular bail, your lordship. I'm in custody since 9 months.
Custody from?
Charge sheet from 2/7/24.
2/7/24.
Yes, your lordship.
Custody?
Custody since 6 March 24.
24. Yes.
I am for the bank manager. Informant manager.
Informant. Yes. What are the allegations?
The allegation manager, there is a misappropriation of the public money to the tune of 3 lakhs, 3 crores. My lord.
3 crores.
Yes, my lord. 3 crores only.
And the amount is given to this petitioner's negative account. This is the allegation. The media has written a letter.
Pradeep Patnaik. Yes.
General manager type the matter. On January 1,
Yes, yes.
During the tenure of 6 weeks, and also informed that confirmation was received from the letter head from their branch head on various dates about the balance itself and the see if deposit in response branch inform video office on the remote of specific was booked. But this the branch manager and national manager previously they have intimated that there has been
Who is he? Who is he? Who is he?
Present
Kumar Marana.
Present petitioner is the assistant manager of the.
Assistant manager of the
Yes,
bank.
ma'am. So he is
What is attributed to him?
Hence, idea that last paragraph. Invested on loss, negligence, and misconduct was not against Sorostan Mark and or Hon'Ble. It was ordered that 95 factories loans, majorly Mudra loans, were sanctioned by the branch, mostly in favor of close relatives, acquaintances of the assistant officers, Hon'Ble Kumar, and branch head Sorostan Mark.
So the loan were sanctioned in favor of the relative of these people. The loan amount has been paid back or not? But loan amount is paid back. Yes.
Your Lordship, one letter was addressed by the Puri collector, letter number 1720. The concerned EOW has seized the article in concern. They have stated, as per the block audit, as per the report of the collector, the total unauthorized transfer has been misappropriated by the concerned BDO officials, Your Lordship.
Where is that?
It is with the concerned EOW officials. Let them.
You are giving the letter number and not give me.
It has been stated in the charge sheet, Your Lordship, in seizure list.
Show me. Seizure list, yes. Yes.
The concerned BDO officials are being involved, Your Lordship.
Yes, show me that seizure list.
Lordship.
You might have got it. You have a charge sheet with you.
They have the charge sheet.
Charge sheet has been filed.
Charge sheet
Copy is given to you.
Charge sheet copy has been given.
Given to you.
Yes, Lord.
File that document.
Your Lordship, I'll file the document. I'll call for the documents.
Yes. The counsel for the petitioner seeks adjournment to file additional document to substantiate his case, leaves the matter up. That's if that is your whole case, that document you should have brought on record immediately.
Lordship, I'll pay.
Yes. Next, 120.
122.
All right.
52 million. Directed for 302 and 328. Analysis of CD is not common.
Call for CD. CD is awaited. Yes.
Another date may be given.
Yes. Yes.
123.
My lord, the advocate is suffering from fever, so I need a urgent time.
Learned counsel for the petitioner submits that the conducting counsel is suffering from fever. Then seek for adjournment. Yes.
124.
May I please?
23
And he
They have filed the deal.
but he says that
Only a lot.
Mr. Bose appearing for the opposite party.
May I please, yours? My lord, on behalf of Mr. Sunil Pandawala, I may allow to place the application.
Sorry? Yes.
My lord. This application, my lord, the petitioner filed for restoration of
Restoration.
My lord.
Delay? How much?
Delay the 3/1/2023, the due to non-appearance of the council. The
Delay 511 days.
My lord.
How? What are the explanation? Just
As because my lord, the conducting council never intimated the present petitioner, my lord. When he could know about the dismissal of the case, my lord, thereafter he filed the restoration application, your lord.
who was the conducting lawyer?
My lord, one BC Swine. BC Swine. BC Swine.
It's very easy to blame the lawyers. Except that you have not said anything.
When the petitioner.
What about the merits of the case? Do you have any merit in?
Yes, my lord.
What was that case which was dismissed? You have not filed anything. Yes. What is that? What was that case? You are seeking for restoration?
My lord, the second appeal has been filed by the present petitioner, my lord. Second appeal has been filed by the.
That was the second appeal.
My lord, the second appeal filed by the present petitioner. And since long the matter has been not listed.
Madam, for the reasons stated in the application for condonation of delay, the same is allowed subject to the petitioner paying a cost of rupees 2,000 to the High Court Bar Association. And the main petition issue, the file is restored to the petition is allowed, and the essay second appeal number 198 of 1997 will be restored to its original file. This is second appeal for hearing before appropriate bench, subject to submission of the honorable chief justice. Yes.
Oblige, lords.
Oh, थोड़ा सा ठीक है.
125.
Can be taken up from other terminal. On behalf of Mr. Agarwal, he has joined the state panel. Mr. Agarwal is no more, he has joined the state panel. So the file, he has sent the file to me. And I have sought for instruction and your lordship's last order.
2012 matter, interim order is operating. I am very reluctant to give extension.
Short date, your lordship.
That short date only, it's going on since 2012.
It's a file, he cannot conduct now. He has joined the state panel.
Only 12 years. Only 12 years. Short accommodation and short accommodation.
I would have bullied your lordship directed to solve a copy because they have lost their file.
I'll release it on 7th. Okay. 7th of this. See, because of your problem, they are taking advantage of this. Let it be, let it come then. What can it? You people are supposed to apprise the court that there are stay operating, and I am asking the registry to get it listed. You people are asking for time. Let it be. List it up after 3 weeks. After 2 weeks. Yes. Okay, after 2 weeks. Not interested.
Interim order.
Yes. Interim order to come. Because of the interim order, it is going on. Otherwise, when merit, you will see nothing will be there. After 2 weeks, you should have collected the document. You should have been more vigilant about it.
Got one is that I have finished so can they go logging in my
But see, since last 12 years, the stay is operating, and today, even if you put to trial, and almost all the witnesses might have been died. And who is responsible? He is not responsible according to me. Responsible is the prosecution. When it is listed, you are asking for I don't have file, I don't have this. Anyway, we'll see. Next. Interview. Not 7th.
Both
yes,
items.
Problem. Yes. 27 also. 120.
No. That's sub item tax.
Yes.
126.
126. Yes, sir.
376 to N 6 post of compromise.
No, it is not a compromise, Lord. My Lord, yes, my Lord, here
Notice was issued.
and
1 minute.
they are very blessed with the child.
Sufficient. Yes.
My Lord, here the petitioner and the opposite party have made possible 3. The legal married wife. But this affair was lost by that child protection office. And there they mentioned that at the connivance of the family members of the victim, they are living.
Who is appearing for opposite party? No, opposite parties. I'll just pass over and see.
But
I'll just.
notice is that though the notice is duly held sufficient. There is notice that there was notice held sufficient. But nobody is that.
Let us see.
My Lord, may I Lordship's indulgence to mention item 173. Your Lordship has specially given a date to hear the matter out.
I think the way today.
that I'm saying,
I think I
that
can
I'm-
reach that.
I may pardon to mention, Your Lordship.
Just now, Ms. Mishra served me a copy of the vacation of stay. In that, they have annexed certain documents.
139. Okay.
Ms. Mishra just now served me a copy of vacation of stay. I only pay next time I take instruction.
Your Lordship, I have not submitted any new document that is not there in the petition, Your Lordship, because this is an after notice matter, Your Lordship. If Your Lordship will adjourn that, then again we have to mention it before the Lordship. It's not coming on.
What do you want?
So Your Lordship may take it up and Your Lordship may adjourn it when it comes up. Your Lordship may hear it once and then Your Lordship may adjourn.
It's all right. All right, I'll reach. Anyway, same thing you can tell when it is done.
I may pardon to mention, Your Lordship, item 135. Your Lordship, after launch.
135,
Your Lordship.
interim order is there?
Yes, Your Lordship.
Wait.
I am for the opposite party, Your Lordship.
No, even if the joint request is made, if there is an interim order, I'll have to deal with it.
No, I have no objection.
81 or 85 was covered. This one has come forward.
No.
It is after twice.
Only.
What do you want now?
Just I pray before Your Lordship.
Lordship supposed to allow that application.
You are for the son, you are prosecuting your mother who is 97 years.
After launch, I have some difficulties, Your Lordship.
No. I told you last time I'll quash it. She is 97-year-old, your mother. Only because you have a dispute with your brothers for property, you are prosecuting your mother.
Your Lordship,
No. Either today or never.
Launch for it.
No.
127.
See this matter. You see, she is 97. I don't know tomorrow what will happen to her. What is this going on? No. Please don't.
Tomorrow or the day after tomorrow.
Shall I count how many days you have taken? Shall I count it in front of your 4/1/2023, 15/4/2024, 30/4/2024, 7/5/2024, 9/5/2024, 23/10/2024. Now again you are asking.
There is an interim order, Your Lordship. I have no objection.
No, I want to put it in end. Yes.
My Lord, 126 pass over, my Lord.
We pass over.
My Lord.
In quashing of FIR.
Yes, Your Honor.
Hold on. Petitioner is seeking quashing non-appeals for the petitioner even in second call. The petitioner is seeking quashing of FIR number Banki PS case number 467 of 2023. 2023 for the FIR was registered for alleged commission of offences punishable under section 341/324/307/506/34 IPA. After investigation, charge sheet has been filed on. Tell me the charge sheet date.
But the charge sheet is filed, but there is the mention that case is called 302, case 49.
49. However, the victim appears to have expired in during the investigation. Therefore, the case is converted to offence punishable under section 302. Hence, I am not inclined to entertain this petition. According to this. Yes, next.
79.
Yes, 79. What is this? What is he asking? Miss Mandal. Non-appeals for the petitioner within the second call. Hence dismissed the matter on non-prosecution. Yes.
83.
Yes, what is this matter?
Impersonated, they have transacted the sale deed.
You said there's some lawyer is involved or something.
Yes. Information is the similar.
Nobody is coming forward. What to do?
Seeking quashing. Non-APS for the petitioner. Even informant is the senior counsel. Senior counsel. Petitioner, non-APS for the petitioners, even in the second call, the dismiss for non-prosecution. 88.
My lords, the matter relates to a one-sided inact proceeding, my lords.
Yes.
Petition is an elderly person, 70 years of age, my lords. And in this case, he is the accused, my lords, an old person. In this case, prosecution evidence has been closed. The petitioner, the accused, my lords, he filed a petition under section 315 CRPC to allow him to give defense evidence. But it was rejected on the ground that it is the case of the year 2016. And the petitioner has taken several adjournments. That the impugned order.
You want to examine yourself as
myself.
Yes.
My lord, may kindly have a look on the page number 20 of the impugned order, your lordship.
Yes.
Last paragraph, your lordship. On perusal of the case record, it is found that this case is of under section 138 and is a case of year 2016. Since 21 June 2024, it is lingering for arguments, and evidence for the side of the accused was closed after giving 11 number of adjournments. But the accused did not.
I have admitted, my lords. I have admitted.
What is the check amount?
Check amount is, my lord, it's
30 lakhs.
30 lakhs,
Yes.
more than 30 lakhs, your lordship.
And I am
11 number evidence. The adjournment thereafter also, your lordship has taken 5 number.
Lords.
5 number adjournments.
Next, sir, my lords.
And the complainant is 83 years old, your lordship.
A petitioner is
Give 20,000 rupees as a
petitioner is, my lord.
20,000 rupees cost, one opportunity. Simple.
Your lordship.
Petition is agreed by the order dated 17/9/2024, whereby the application under section 115 CRPC to examine himself as a defense witness has been rejected. Petitioner is facing the prosecution initiated by opposite party for alleged offenses, offense punishable under section 138 NIA. The complaint case is pending since 2015. The evidence of the parties has been concluded, and thereafter the matter was set for final disposal. The petitioner have sought as many as 11 adjournments.
11 adjournments prior to his evidence are closed.
11 adjournments. When the matter was supposed to be argued finally, at that point in time, the application under section 315 CRPC was moved by the petitioner. Hence, the trial court has rejected the application on the ground that the petitioner is employing the method to prolong the trial unnecessarily. Then counsel for the petitioner submits that petitioner is facing the charges of dishonor of check of amounting to 30 lakh rupees.
More than 30 lakhs.
More than 30 lakh rupees. And he has an indefeasible right to defend himself. The default on the part of the petitioner is for various reasons, which has not been dealt upon by the trial court. Be that as it may, I am not inclined to enter into the reason for which the petitioner has sought adjournment time to time. I'm of the view that the petitioner should get an opportunity to lead his defense evidence by examining himself as a witness. Hence, subject to the petitioner paying a cost of rupees 20,000 to the complainant, the petitioner is allowed to examine himself as a witness to his witness on his defense. Accordingly, the impugned order is set aside. The petitioner, the trial court is directed. The JMFC Soro is directed to afford an opportunity to the petitioner to examine himself as a defense witness, and it's made clear
that the petitioner shall not seek any more adjournment on any pretext whatever.
Yes.
Whatever. And he would conclude his evidence on the day to be fixed by the trial court. Trial. With this observation, the petition is
It was targeted. My lord, I have filed my argument, notes of arguments also I have filed. Yes. Well, at this stage, yes,
after
come.
the trial court further directed that after the evidence of opposite party, evidence of the petitioner is recorded, the matter should be heard and decided as expeditiously as possible, within not exceeding 3 months.
4 months, your lordship earlier directed.
Huh?
Earlier, your lordship had directed 4 months. In
3 months because
in 2023.
You'll be happy with 20,000 rupees. That's the only concern.
My lord, he's only liquoring the matter, your lordship.
Yes.
Praise for quashing of the affair. Offences available 126(1) and 351. There is talk of compromise. Notice may be issued to the informant OP number 2, my lord.
What are the allegation?
Allegation that the petitioner had slapped the informant.
Okay, you take out notice. Issue notice. Yes.
Pardon to make a mention, my lord. Item 83, sorry, my lord. Item 83 may kindly be taken, my lord. Sorry, I am extremely sorry, my lord.
What
Item 83. 83. I am Discharge Puri, my lord.
You didn't come, I dismiss it for non-prosecution.
Sorry, I am extremely sorry, my lord. I am engaged in other court. Sorry, I am extremely sorry.
I'll recall the order and release it. 83 dismissal before correction.
My lord, there is a chance of compromise. Notice may be served to the opposite party number 2.
What are the you have not, sir? We have not. You have not filed anything except FIR.
My lord, I pray FIR, Quashing FIR, OP number 3 agreed.
That's right. What is the stage of investigation?
Investigation already in progress, my lord. However, the informant already agreed to compromise, my lord. He happens to be maternal uncle, OP number 2, my lord. That's why I pray, my lord.
Notice. Okay. Yes, no.
Pardon, my lord. Item 70 ta disposition non appear, sir. But next week, yes, my lord. Item 70, my lord.
What is this practice? Everybody is.
Pardon, my lord.
You don't come in time, and any time you come and mention it.
Yes, my lord. 307.
And he was online. There must be some technical problem. Therefore, 302.
Yes, my lord.
Then what? Where is the question? Investigation is still going on. I have not. Only I have said that liberty is granted to you to raise. And liberty, however, liberty is granted to the 17, granted to the petitioner to raise to revive the prayer if cause of action is substantial. Yes.
107.
Yes.
My presence may be.
Yes, present. Yes. Yes, madam.
Your Lordship. The petition is aggrieved by the cognizance order dated 6/7/2024.
Yes.
Annexure 1, page 22.
Yes.
Taken by the learned JMFC ruler, Rourkela, my lords. And for offences under section 498A.
And issue notice 498A.
Your Lordship, interim stay may kindly be granted.
Who are you?
My lord, I am for the petitioner
Husband.
only, husband.
What is
Because,
the stage?
my lords,
What is the stage of the trial?
stage charge will be framed.
Are you going to settle the dispute?
Settlement, there is prima facie evidences because it's simply an afterthought. The wife is already having pregnancy of 1 month, 7 days when the marriage was solemnized 1 month prior. And
all
I have,
these are disputed question of fact.
yes, your lordship, but I have submitted the medical documents.
If you will say that you made such a dispute, I can.
Yes,
Whether
we
she
are
was
ready to-
pregnant, you are not pregnant, and all these things. How can I decide?
Your lordship, I do agree, but my humble submission is that because of the pendency of this case, because the parents are seriously ill, they are under tremendous stress. They are people of Dhanbad, Jharkhand, and the matter is pending in Rourkela. So because of the distance and language problem, they are literally getting harassed. And my humble submission
They
is
are
that-
not accused.
Your lordship.
They are not. Who?
No, she has herself made a confession before the executive magistrate Dhanbad that she is having other affair and whatever. If any case is
Those
filed,
things are again on merit. It has to be dwelled upon.
till the appearance of the opposite party.
No, what opposite party? See, Your
wife is the opposite party number
husband is
two.
only accused.
Only accused because the other people
Because
were
the
also
pendency
accused.
of this case against the present petitioner's parents are stressed out.
Because they are also named in the FIR. Right now, after the filing of the charge sheet, their name is deleted.
Right, they are not accused.
They are not accused, but unnecessarily a false case has been registered.
Application. See, if you want to settle, settle it.
Your Lordship, I am ready to settle. I am ready to settle. But the wife is not coming. She is having criminal antecedent. Her whole family is having.
I'll just issue notice. Therefore, I'll issue notice. Move application.
But interim stay may kindly be granted.
Issue notice in the written rule after 2 weeks or 3 weeks further. In the meantime, the petitioner may move application before trial court for seeking adjournment on the ground that the matter is sub judice before this court. Yes. Next. 150.
Highly
Settled the issue. You don't have a case.
Highly obliged.
Yes.
Pardon, Lordship. Lordship, item 79.
79, while I rising, you mention it. Not that at any time you can come with. Wait. Next. 115. Stop this practice of interjecting in between. Okay. Stop this practice of interjecting. If you don't come, wait till the end. And while rising, you mention it. That's the practice. Yes.
The petitioner has approved this honorable court on 482 of said PC. For the quashing of the FIR, the laws are under section 13.2 and redo 13.1D of the PC Act.
Yes.
The petitioner is a revenue officer. He is a Tahsildar. He has given by invoking section 8A, he has converted some lands.
How can I go into all these things, sir? In a Prevention of Corruption Act, you want quashing of FIR?
Being a officer that is protected under section.
The prevention of corruption only officer can do. Who else can do?
Under section 70, my lord, that is a prohibition not to institute any case against a civil servant, this revenue officer, while passing the order in a judicial proceeding, my lord. So, had there been any mistake, it has to be done by the collector.
I don't know whether you pass in the judicial proceeding. It is at the FIR stage. Nothing is. Investigation is going on. Investigation is going on. You tell all these things to the.
My lord, can have a glance to section 70, my lord, of the OLA.
I can't see at this stage. Investigation is going on.
No, investigation is not going on. That is minimum 8 years has been passed. No, sir, nothing has been filed.
No,
the incidents in 2000.
Therefore, investigation is still going on.
Might.
Investigation is still going on.
Well, I am coming before this court because I am a revenue officer and I have whatever I have done in my bona fide manner by invoking section 18A.
You tell all these things to the IO and IO should take it to consideration in accordance with law. Right now, petitioner is seeking quashing of the FIR VGR number 32 of 2018 corresponding to Kotak Vigilance PS case number 33 of 2018 for alleged offences punishable under section 13.2 read with 13.1D PC Act and 420/120B IPC 420/120B IPC. And counsel for the petitioner submits that though the FIR was registered on 17/7/2018, the investigation has not yet been concluded. Moreover, the petitioner is was working as Tahsildar, and he has passed some quasi judicial order. Hence, he is protected by the immunity provision under section 70 of PC Act. 70 of
OLR Act.
70 of OLR Act. Because he has passed the order on good faith, on good faith, and the said order is a quasi judicial order. Therefore, the entire case which hinges upon the order passed by him in the quasi judicial, being a quasi judicial authority. In that view of the matter, the FIR is liable to be quashed. I am not inclined to entertain this petition as the investigation is still going on. However, liberty is granted to the petitioner to apprise all these aspects to the investigating officer, who shall take into consideration these aspects in accordance with law while filing his report under section 173 CRPC. With this observation, the petition is disposed of. Yes, next.
My time limit, maybe. Time limit is given to that I have to approach because they will still pending.
Better time limit is not given, so that you will be, they will drop it. Because 2018, nothing is happening. After this observation, they can't file charge sheet. This is the reality. Yes.
126.
Mr. Quashing, for offense 76 2N, 76 post. Here is the informant is the district protector, legal assistant or child protection officer.
Informant. That is opposite party number.
They are not added as a opposite party in this case, but
Who are 2, 3, 4? Who are 2, 3, 4?
2 is the informant. Sorry, informant is 4. Tapon par panda. Say, but the dekhi pan nanti.
4 service dekho.
Victim is 3.
Huh? Four.
3, 4 submission.
3, 4 submission.
Here, my lord, what is simple phrase that the opposite party number 3 is now married to the present petitioner, and they are residing with the parent of the present opposite party 3.
Everything is all right, but see your cost, at least she is, even today is 17.
370.
Then POXO is there, how can I get out of it?
You have already married and
maybe whatever.
blessed with one child.
That's right, but she knew recent judgment. Otherwise, you are covered by matrimonial.
But that so far that is concerned, that is amicably settled, but not husband and wife. I have verified, my lordship has directed
What
to
is
verify.
the same issue, same thing.
No, that is amicably settled, but it is not settled. They are staying under one roof as a husband and wife.
But FIR is filed.
FIR is not filed by any of the family members.
That's right, but
that was by WC staying. Well, it may be a child marriage act, but not 376 2N. Unless there is an allegation made by the victim or the family members.
Every POXO act where they're married, then the same.
No, but I'm not arguing on merit. But no case can be filed under section POXO because there is no allegation neither from the victim nor from the family members of the victim.
What do you say?
The facts in the allegation in the
very difficult because you are teacher. That's the whole difficulty. Teacher and age is difference is just double.
Marriage पर आओ का सेटा धरा.
That's right, but see, the entire idea of the act is defeated.
Little bit different.
Idea of the act is defeated. That's the whole difficulty.
Filed by the
and that
family members.
482 you want causing.
My lord, had there been allegation?
See, that girl will go and not support the prosecution case. You will be acquitted. But 482, I can't quash like this.
But neither the parent nor the victim. There is
so therefore, there won't be any evidence against you. Face the trial and finish it up. I'll expedite the trial. That's a better idea. I'll expedite the trial. And the prosecution will not get any evidence. Because the girl
no evidence will be.
Girl is your wife.
Now is
the parents are also with you.
My lord.
So I'll expedite the trial. That is a better idea. If I'll expedite the trial, you will be acquitted. I'll fix the timing also.
One adjournment.
You are on bail or not?
Bail.
Then?
By this honorable court. By this honorable court.
Then what is your problem? I'll dispose it up. It's a better idea, Otherwise, this case will be unnecessary pending and their family life is getting, affected. What do you say? He has a problem.
17 years age 18 ହେଇଗଲା ପରେ ଟିକେ ସୁବିଧା ବୋଲି ସେଇଥିପାଇଁ ଟିକେ ୱେଟ୍ କରିବି ଆଉ 2 ମାସ ଅଛି ପରେ ହେଇଯିବ ତେଣୁ 18 ହେଇଗଲା ପରେ he has every right to say
no by the time
the occurrence took place minor.
What is the stage now? Stage of the trial.
For trial. They are ready for trial.
Charge has been framed?
Charge has been framed.
By the time evidence will be recorded, she will be I'll give 6 months time to conclude the trial. And at least within 6 months, you will be free. If this matter will be pending, I don't know when it will come. So therefore, it's better that I'll dispose it up. Recording his statement, I'll dispose it up.
Say observation खाली कर देते हैं.
I'll record your statement.
Obliged.
Right now. Which item is this?
126.
126. The petitioner is an accused in PS case number Janapur, PS case number 189 of 2021 for alleged commission of offence under section 372N IPC and varied with section 6 of POCSO Act. The opposite party number 4, who is what is he? Who is the LPO, legal cum protection officer, DCPU, Jajpur, has filed the complaint against the present petitioner, leading to the registration of the FIR. In the FIR, it is alleged that what is the allegation?
Allegation they are staying in under one roof as a husband and wife.
Mother-in-law.
With mother-in-law. Running page. Last 3 lines, my lord. They are residing with the
has been, what is written has been? Just see.
Running page 16.
I read it. What is it?
First para last.
Presented by one Rajkumar Raut, age about 30 years, who is working as a teacher in so, and they were residing.
Connivance with family members.
Is that the present petitioner has been residing with the victim girl, namely the opposite party number 3. Opposite party number 3 in a rented accommodation. Yes, rented accommodation, and the family member of the victim girls have been supporting the alliance. After investigation, charge sheet has been filed in the present case for alleged offences under section so and so, and cognizance for the said offences has been taken. Full charge sheet charge has been filed against the petitioner, and the petitioner is put to trial. At this stage, the petitioner is seeking indulgence of this court for quashing of the entire proceeding on the ground that on the facts of the present case, no case either under section 376 IPC or under section 6 of POCSO Act is made out, because the petitioner and opposite party number 3 have already married and residing residing together on the consent of the parents of both the parties.
Okay.
Therefore, at best, it would be a case of under child marriage act. Then I'm not impressed by the argument put forth by the learned counsel for the petitioner from the fact that the case is being registered at the instance of the child protection officer, and the trial is yet to begin. And the facts and the contention raised by the petitioner in this petition could only be thrashed out in the trial. Therefore, the petitioner is already on bail. Therefore, although I am not inclined to entertain the present petition at this stage, however, liberty is granted to the petitioner to raise all the points before the court below at the appropriate stage. Regarding head to the peculiarity of the facts of the present case, I am also of the consider view that the trial court should do well to see that the trial of the present case is concluded as expeditiously as possible within a period of 6 months hence. With this observation, the petition is disposed of. Yes.
Obliged.
127.
May I please, Your Lordship, on behalf of Mr. Ponda, 127, 128, please one chapter.
Interim order is there. No interim order. Notice on the opposite party number 2 would not be served for want of appropriate proper address. Land counsel for the petitioner is directed to furnish fresh address and issue notice, fresh notice and the address to be furnished by the petitioner. Yes.
Okay.
Next.
128. Awaiting service.
128.
Awaiting service.
Awaiting service on the opposite party number 2. Least the matter of such. Yes.
129.
Yes, ma'am.
His Lordship, the petitioner is they challenge the cognizance taken by the magistrate under Annexure 5 along with the in-laws members of the opposite party number 1. There is a family dispute of the opposite party number 1 to opposite party number 4 amongst the 1 to 4 mile. But the petitioner is the custodian, that is the president of the Nari Sangha Bhavan. Only the manager is the short stay home. She only allowed to stay the opposite party number 1 for only due to the matrimonial dispute. Only to police presented her for taking the rescue. So allowed her. Thereafter, she at the time of entry into the Nari Sangha, she submitted all the articles and Jimana was everything was taken, inventory was taken. After sometimes he released from the Nari Sangha place, Nari Sangha Bhavan, and he got back all the articles. Thereafter, what intentionally she lost the affair before the.
Don't tell me all these things, but tell me how the cognizance order is wrong.
Cognizance, my lord, along with there is no fault at all on the part of the petitioner. Along with there is a dispute, the matrimonial dispute among the opposite party number 1 to opposite number 4. But there is no nexus of the family dispute of the petitioner, my lord. Petitioner is the president and he only allowed to remain in the custody, my lord. And only she told that is the affair laws.
I'll issue notice, but
and my lord, on the protest petition.
Yes.
Yes, only the
I know
final report has been submitted. So only protest petition.
1 minute. Come to
my lord. Notice has been issued, my lord. Lordship C. Only opposite party number 1. Only the notice not sufficient against the opposite party number 1. Every year also notice is there.
So why are you telling so many things?
Because there. So it is not on first.
No. Awaiting notice. You don't have a case at all.
My lord, this honorable court has allowed the my lord. This is the order.
Allowed what?
It is only to adjourn the matter by the magistrate. Because otherwise no notice has been issued to the petitioner. Lordship see, that is the dated 3/10/2024. Only the sent to the Mediation Center.
Mediation. What happened? Mediation.
Mediation, that did not come. That is there. The opposite party did not come. Because I have no.
1 minute. One matter was referred to mediation by this court by order dated 3/10/2024. And counsel for the petition submits that the opposite party are not cooperating in the mediation process. However, the mediation report has not yet been placed on record. The coordinator of mediation center is directed to issue fresh notice to the opposite parties, and after exploring the possibility of settlement, file a report. Please the matter on so interim order continue. Right? Yes.
130. No, will extra. This case shall be abated.
Land counsel for the petitioner submits that the sole appellant in the present case has expired. The appeal stands immediate. Yes.
131.
131. I appear for the appellant Kedarnath Bisoi in criminal appeal 328 of 14 and in criminal appeal 153 of 14. He has died and a petition for substitution is pending.
Kedarnath,
Yes.
you are in the last item. You have filed already application? One criminal appeal 153 of 2014. Mr. Pandal and counsel for the appellant submits that the sole appellant in the present case has expired. And wife has filed.
Milords.
Who has filed the application?
The legal heirs, Milords.
The sole legal heir or
no. Widow and okay.
The legal heirs of the appellant has filed an application under section 394 CRPC seeking for impleadment in the appeal. For the reasons stated in the application, the same is allowed. Amended memo of parties may be filed within a week. Least the matters, at least all the appeals for a hearing in the weekly. Yes, I allowed it. Yes.
Same order, Milords, in the other connected appeal.
No. Who has died there?
See, Kedar Vishwipra.
Achha, there are two matters.
Aye.
Okay.
153,
328 of 14
Aye.
also. Okay. Yes.
132.
Yes. Yes, who is appearing? Huh? None appears for the appellant. Huh? Achha, on the joint request, list the matter in the weekly list for hearing. Okay. Yes.
133.
133.
133 played for after vacation, lordship, for final hearing.
Why, madam?
At 33, there was no stay of suspension because of the opposition by the Vigilance Council. Your Lordship, this we want to also place on merit. So I am praying for a reopening week so that we can assist your Lordship.
List it up. Yes. You take it.
Maybe instruction court master.
I have already given standing instruction. Standing instruction. There is no problem. Yes, you can take it. You send your junior and take it. Don't go to all this formality. Ready to argue the matter. That's all.
I was also told that your Lordship is making a system where we can have access to these things. That system should be implemented early.
Everywhere. These are in
these have not been done here, where the lawyer gets a code. Have you got a code? No. Lawyer gets a code.
I have already told you get a pen drive, take whatever is there. These are not classified documents that you won't get it.
Now we are doing it, but I was told that your Lordship is implementing a system by giving a code to each and every lawyer where they can have access to this.
That also we are in the process of doing it.
Yes,
but to begin with,
because
you come with a pen drive, take whatever documents are there. Because see, you are the accused. You have been convicted. No document is a classified document for you. Any document he can rely upon and which is part of the record, he can try to do that. Where is the secret about it?
Government councils can have access to all the petitions and everything. I think they have a code with
Yes, of course.
So like that, we, the general council should have.
It should be open. It should be open. Nothing, no secret. You take it from the court. No formality, no application, nothing is required. You take it. Get ready with written submission and.
Yes.
I will
handle star is very difficult.
I for stay conviction will lie.
It seems he is very ambitious. He wants stay of conviction.
Because
notice may not be granted, that's a different thing.
I think you can try in 2025.
For a lawyer to be ambitious, there is nothing wrong.
My lord, because yesterday notice under section article 311 issued. But
why will you waste time in arguing to convince me the conviction to be stayed? Rather I'll dispose of the appeal at that time.
Opposing stay of conviction.
So better let us go into the evidence and if you are entitled to acquittal, go and acquittal.
Yes. The continuation of trial is not
nothing there. Yes.
When the second matter in item 1.
My second matter, initially it was adjourned to 12th of December.
All the matter will come together. Yes. Yes.
9.
Yes. 134.
134.
Pen drive.
134, your lordship, I'm filing my wakalat number today. We got the consent to
For whom? For whom?
petitioner, your lordship.
May I please, my lords? I'm appearing for the opposite part number 2 and I'm filing additional.
The entire team is changed.
No, my lord. For opposite part number 2, team has been extended, my lord.
Okay.
Not changed.
Okay. The so and so entered appearance for petitioner and so and so appears for opposite party. No, please the matter for you. Yes.
My lord, my name will be reflected.
Give further adjournment on this petition.
My lord, my lord.
Yes. But today mediation is fixed. Why don't you go and participate there?
My lord, mediation has been failed, my lord.
Failed, huh?
Yes, my lord.
Okay.
Mediation has been failed.
Mediation report hasn't come. Yes.
My lord.
135.
My lord, my name may be reflected on
Yes.
this. Grateful, my lord.
Names of the lawyers has to be reflected. Yes.
The order of cognizance.
I know. You are from other.
With your lordship's permission, only I will submit your lordship one line.
Why don't you settle? After all, she is a mother and 97-year-old.
I understand your lordship. There is tankar dita bhai is also, they are also accused. Our petitioner kebal file karche.
देखिए accused किया अଛନ୍ତି.
Your lordship kindly come to the page.
Shall I quash the FIR, quash the petitioner only?
Yes, my lord.
For a moment, your lordship, I may permit to place only one line. Thereafter, your lordship. Your lordship kindly come to page.
Yes.
That is charge sheet, page, running page 45, your lordship.
Yes. What do you want to say?
Your lordship, may I permit to read your lordship that line.
Tell me what you want to say.
Just one line only.
Read it. How many times you will say one line?
Yes.
Read it.
Further, the opinion on the dispute signature was received from handwriting bureau SFSL Bhubaneswar, in which it was clearly mentioned that the signature of the complainant in the affidavit is not his signature, which proves that Srimati Malati Devi has produced another person in the name of Anant Parida, the present informant, before the executive magistrate.
I accept your argument. Yes. That your mother has done everything, but look at her age. She is how much? She 82. 22, 82. Today she is about 84.
Yes, Lord.
If your mother has done something, you will fight with your brother and sister, and your brother and sister are using your mother,
both,
and therefore you will prosecute your mother.
No, I'm not saying your lordship.
No, you are saying everything.
Your lordship, in GR case, the two brothers are.
You fight it out, your brother will do whatever. I want that your mother to
permit only one thing.
Yes.
Your lordship may quash, but let them permit to reside in that house, your lordship.
This is the 482. I will not pass injunction orders like
Your
this.
lordship kindly say, just a minute.
How can I pass injunction order?
Your lordship
I permit you to go and stay there.
See, the informant is a daily laborer.
Whatever may be, how can I pass that kind of order? Either I will have to quash or I will dismiss. These are the two things I can do.
Signature is they have paused, your lordship. You clearly shows that.
In his petition, you want relief. That too injunction against the mother.
Against the mother.
What kind of submission you are making?
He has filed in the civil suit. The annexure to the civil suit is filed by the son, my lord.
Anyway, I'm listing it on 7th. You come with right prayer. I will quash it. 7th.
Complaint.
Your lordship, keep it on 17th.
7th, Saturday.
Saturday.
Third, yes, next.
Can it be on Monday, my lord?
No, Saturday.
Saturday, Allah.
Everybody is coming on Saturday. Yes.
136.
In your absence also, I'll allow. Don't worry. Don't come. Yes.
Item 1.
Tell you can prosecute your brother, sister, whatever. Your mother who is going to die after some time. Why are you after her life?
Cognizance has been taken in a complaint case.
There before your lordship, because of some dijon bhai misigiri, they have done this.
Suit ta file korte suit ta proceed korunanti. They didn't file in the suit.
Signature ta.
Again, suit ta file korchunti.
Again signature.
In 95 taken 35 rupees, 35,000 rupees. Left the home. The document with me. Everything is for.
Are you speaking for the mother or you are speaking for the?
And for the mother, my lord.
No, but
he has filed the suit against the mother.
In GR
This is you are pleading for the other children.
No,
with
I'm
whom
not
you are
saying-
there.
no, your lordship may, whatever it will.
You people are, both of you are using your mother for settling the property.
No, my lord. I am coming for my mother, your lordship may quash it, that's my prayer only,
Yes.
nothing else.
I'll take care of both the things.
God bless.
Don't worry.
mother can your lordship may pass.
No, you can't. Both of you can't use your mother for settling a score for property. Have you earned property?
No.
Your father has earned the property.
Yes.
And you people are fighting using your mother?
I am not.
I will allow this and impose right cost on both of you because you are using your mother.
No, your lordship.
Nothing
You
doing.
kindly come to the FIR also.
Nothing doing. I will not read the FIR. Nothing.
And the your lordship the
Saturday.
ଦି ଜଣ ଯାକ ଭାଇ ମିଶିକିରି mother କୁ implement କରିଛନ୍ତି.
And you are also like that. Don't
No.
worry. Yeah. Yes.
ମୁଁ ନଥିଲି actually.
Yes.
136 of that.
Item 136, I pay for adjournment. Unless I am appearing for the opposite partner to your lordship. Previous occasion also I have already filed my objection. Copy has been served. 136, your lordship.
Yes.
And for the opposite
Yes.
party number 2.
Yes.
I have already filed my objection and the copy has been served to the petitioner.
Why adjourned, sir? 2020.
Mr. Das is ill, my lord. So I pray. The previous occasion also they took an adjournment.
Have you taken the objection?
Yes, they have. There is the noting also there. Copy has been solved. Objection copy has been solved.
There is no interim order.
Is not in on 20 February 2024. An order has been passed that if an adjournment petition is moved before the trial court, the same shall be allowed, taken into consideration. That is affecting the trial because now the stage of the case is that the evidence from the opposite party, that is the present petitioner, will be taken. They have taken 10 adjournments. After that, they have filed this present petition.
See, you have filed a petition which you have merit or no, I don't know, and you are seeking adjournment there.
Mr. Das is ill, man. So I pray.
Next week, Roko.
Next week.
Next week, Roko. On the ground, health ground, I can't.
I'm alone.
Yes.
137.
Oblige.
Yes.
May it please, ma'am.
Yes. Yes, sir.
Now, in the
What is
first
this
matter, you have filed an additional affidavit or bringing one document on record, that is the statement given by the DDM before the, as part of the police papers.
Yes.
Supplied to.
What are you seeking in this petition?
I am seeking quashing of proceedings.
Yes.
The entire criminal proceedings minutes in this.
Who are you?
I am the minutes, the company.
Okay.
Which has been alleged, there's an alleged violation.
And who is petitioner number 2?
Petitioner number 2 is minutes, the director, ex-director.
One of the.
Ex-director.
Okay. Hey, what are you showing? Yes. What is this affidavit?
Director.
Yes, sir.
Now, this is virtually arising out of a clerical error of entry in the books of account, which has now has courtesy the ingenuity of the vigilance department.
Yes.
And a bit of vindictiveness, it has snowballed into a criminal litigation, where my submission before your lordship is the entire foundation is not there. Now the litigation, I'll just give a brief overview, then I'll show your lordship the facts.
Yes.
Now the license, there's a license granted under a rule under the mining mineral OMMC, OMPTS, Odisha Mineral Concession Act, Minor Mineral Act. The rule is known as Odisha Minerals Prevention of Theft, Smuggling, Illegal Mining, and Regulation of Possession, Storage, Trading, and Transportation Rules 2007. Now the preamble to the rules says, in exercise of the powers conferred under Section 23C of the Mines and Minerals Development and Regulation Act, Central Act, 57, MMDR Act.
Yes.
The state government do hereby make the following rules for prevention of theft, smuggling, and illegal mining.
Yes.
This is the key. The act is geared to check these three activities, my lord.
Right.
Theft, smuggling, and illegal mining. And to regulate possession, storage, trading, and transportation of minerals in the state of Orissa. Now, my lord, there are two parts to it. One is that storage, transportation, possession, storage, and trading. And they have to be, officially, they have to be legal. They have to be legally done to ensure that, and to ensure that there is no theft, that there is no indulgence in theft, smuggling, and illegal mining. To prevent that, they have enacted these rules.
Yes.
Now, the entire allegation against the petitioner is this,
Yes.
Condition 7. There's a rule 7. Rule 7, sub-rule 2.
Yes.
The licensee shall be granted in Form D subject to the following conditions. The licensee shall maintain a correct and intelligible account of minerals procured and transported daily to different destinations in the format prescribed in Form E. Now, there has been admittedly a discrepancy here.
Yes.
Now, this involves two companies. Both the companies, they are not lessees. They are trading companies which also have export license. So, it is in the business of procuring when the mining business was in a boom. And in fact, the normal course of mining business, there are certain companies which are exclusively into trading, certain companies which are lessees, they have mining leases.
Who is lessee here?
Lessee, we procure materials from various.
Okay. You are a trading company.
Yeah, I am a trading company.
Yes.
I have an export, both the companies have export license.
Yes.
Now, in one case, they say that the transportation has taken place because there's an indent also given by the railways. So there's an indent for transporting the ore from the lessee's site to the wherever the port, who port it? Gangavarman port here.
Yes.
So for that transportation, there's an indent for transportation indent. So what do they see in the transportation indent? They see first whether the ore has been, the royalty has been duly paid upon on the ores, and whether all statutory dues relating to the ores is clear. Once that is clear, an indent is procured.
Yes.
An indent on the indent after verification. The ore is What is verified is that it is legal. That the ore is legal. There is nothing illegal about the ore being transported. And then subsequently from the port, it will be exported. Now, admittedly, it is nobody's case, and it is not the case of the vigilance, that the ore is illegal. I would emphasize this, my lords, with a lot of emphasis, my lord. It is entire ore, every ton of the ore, single ton has been duty paid. All duties, royalty, and other duties, my lord, have been paid on the ores. What has happened here? My two companies.
You have very transit permission.
Yes. So one company, my lord, we export orders have come in, so we have to satisfy the export orders. So one company, the indent ran out of indent. So and it had applied for new indent permissions. It was awaited. So orders had to be supplied. So the sister concern, the same company's sister concern, the ore belonging to the first company, Rashmi Metallics, was carried by the indent of the second company. And the indent of the second company to Gangavarman port. Thereafter, it was exported on a valid license. There's no difficulty there. Only this transportation part. So now there was some and what is the discrepancy? Maximum discrepancy at that point of time. This is 2007, 8. 2008, your Lordship knows in this line of business, there were lakhs of tons being transported, my lords. Lakhs and lakhs of tons being transported. The DDM, the director focuses, pinpoints on this company. It's like needle in a haystack, my lord. For some reason, for some mysterious reason, this company was targeted. And there's a discrepancy in your records.
discrepancy in your books. So therefore, you are unable to satisfy, the languages, I'm not convinced with your explanation. So I'm suspending your license.
License, okay.
So we approach the High Court. High Court says, and he keeps it pending. The DDM keeps it pending. For some reason, he explains later that he was busy in his work and all that. So the High Court says, no, you expedite it and grant it. Or we expedite the process in accordance with law. So he thereafter grants the license. The explanation is called for, explanation is given, and he revokes the suspension, allows it to continue.
Right.
The director is not happy. This thing being brought to the notice of the director, he is not happy. 2 months thereafter, he says, why did you revoke the license? You immediately suspend it. So 173 days after 117 days after, a little more than 2 months, 3.5 months thereafter, 3.5 months thereafter, the director orders the DDM that you cancel the suspend or cancel the license, suspend the license. The license was again suspended.
Once again.
Same allegation is the same, for which they had revoked it.
Yes.
And then, my lords, again we had to approach the High Court. The High Court said that the authority who is to deal with the license, he is to apply mind independently. He cannot be directed by the superior authority to act. So therefore, High Court quashed it.
Come to that order first.
That order
that goes to the root of the matter.
153. 153.
53.
Thank you. Tell me that.
Yes.
Page 158, straight away.
158. Okay.
First paragraph, bottom. It appears, I'll just place 3 lines.
Yes.
It appears that once again, Lordship got that?
Yes, I got it.
It appears that once again the Deputy Director of Mines, Joda, directed for suspension of the petitioner company's license until further orders. From the aforesaid facts and circumstances of the case, it appears that the DDM Joda has issued the order of suspension of the license of the petitioner company. But the learned Advocate General fairly submits that no superior authority can direct the Deputy Director of Mines to grant, suspend, revoke the license under the statute. In our considered view, although the aforesaid contention has been made to adjudicate the proceedings, in that case, the Director of Mines would not be justified in issuing a further direction to the Deputy Director of Mines to suspend or revoke the same license.
He doesn't have a statutory authority. That's what
He doesn't
it says.
have the statutory authority. It appears
Yes.
that ignoring the aforesaid dictum of this court in the earlier writ petition, the Director of Mines once again has issued a direction. It's almost contemptuous, ignoring the aforesaid dictum. And then, my lords, this order comes. I'm sorry, my lords, thank you. My friend tells me that this paragraph also should be read. In the case at hand, the last paragraph. In the case
I read it.
Admit
it is admitted that Deputy Director Mines Joda has passed the suspension order once
again in compliance
with
with section issued by the Director of
I read it.
So the self-same cause of action for which suspension order had been earlier issued.
It was recalled. Yes.
This order comes to be challenged by the state.
In Supreme Court.
Yes, at the instance of the director, the state challenges the Supreme Court. 161.
The Supreme Court says that it is on the basis of the statement of the Advocate General.
Yes.
Yes.
What is not there, what is not reflected in the order, I would just like to point out, this matter was filed by the state.
Withdraw it. Because the entire order was passed on the basis of the statement of Advocate.
It's more interesting. It was kept pending without removal of defects. Then when a contempt was filed here, then they immediately listed it in a hurry.
Anyway,
your Lordship knows how that happens. We have heard the matter. From a perusal of the impugned order, it transpires that the High Court order.
I read it, complete.
Malus?
I read it.
Malus.
Yes.
Now, this was the contention that we will move an appropriate application before the High Court.
Yes.
So instead of doing that, exactly 16 days after, 19 days after, 16 days after,
the vigilance, my lord, the director prevails upon the vigilance department, my lord, to launch a file an FIR. So the vigilance FIR has been filed.
This perhaps the Supreme Court, they say that they will move appropriate application.
In the High Court,
indicating that they may file a review petition. Instead of that,
another FIR was filed.
I understood.
On 19/2/2014.
Yes, Mr. Marana, how? What
Now,
is this?
Now, well, it's not only
Prosecution, but then what he says, may be saying, I don't know, preempting his argument. He must be saying that the guideline of Bhajanlal 7 applies to this case. Because it is completely a case of malicious.
Malicious prosecution.
Okay.
My friend will have his say, Manoj.
Yes.
Now, Manoj, let me come tell your lordship, Manoj, what is the allegation, Manoj? The allegation is basically that, and maximum, Manoj, at the highest, it was, Manoj, 3,001.
Yes.
Manoj. I will not waste your lordship's time, Manoj, valuable court time in reading the allegation, because allegation is that. In the first case, it is the allegation is that there was a mismatch in the Manoj.
What is the stage of the
cognizance has been taken? Interestingly,
charge has not been taken.
Manoj, no.
Yes.
Cog was taken in addition under 420 and 120B, whereas the initial allegation was under 13(1)D. 13(1)D.
Now that is dropped now.
No. 13(1)D is dropped, omitted from the statute now, 1. And 2, on the top of it, Manoj, this DDM has expired. It's passed away in the meantime.
Okay. Then 120B and 420.
420 is, Manoj, what remains. Now, Manoj, I'll just...
379 must be there? No.
No, nothing. No, that's why I emphasized in the beginning, every ton of ore, Manoj, duty paid. Statutory duty, everything has been paid. Now, how, Manoj, it's so, Manoj, typical in this case, Manoj, storm in a teacup, I would rather put it in a different way, Manoj, storm in a teacup. There's nothing in this case, Manoj, they've invented a case out of paper. No smuggling, no illegal mining, no theft, nothing, Manoj. We are an official company, Manoj. We are doing regular, respectable, Manoj, trading business in mines. It's not that we have done. Lordship, may kindly come take up my additional affidavit.
Yes.
I filed today. Lordship, may kindly, that's very interesting. How is even page 4 of the additional affidavit statement of the DDM himself.
Page 4.
No.
Yes.
Page 4.
Yes.
What does the DDM say? The deposition.
Which paragraph?
First paragraph.
Yes.
The deposition, last line. The deposition, even the
deposition over the
show cause produced by the company by Sri J.D. Mishra, representing the company, is not convincing. That means, he has explained, that means, this is very important, that means the version of J.D. Mishra over the show cause is not understandable. Now, what does the statute say? I'll for a second take your lordship back to the rules. Rule says here, rescission of license. Rule 9. This is their case. That you should have cancelled. The competent authority may, at any time, Rule 9 of the OMPTS rules. The competent authority may at any time during the tenure of license suspend or cancel the license for breach of any of the terms and conditions of the license, provided that before cancellation of the license, the licensee will be served a show cause notice. If the competent authority is satisfied with the explanation, he may withdraw the order of such suspension and allow the lessee to carry on his business. Otherwise, the competent authority, after giving an opportunity of hearing to the lessee, cancel the license by an order in writing communicated to the lessee and also shall forfeit the security deposit along with the interest accrued thereon to the government. Now, for a second, my lords, we'll pause here. I'll take your lordship to the order. This is the, my lords, the entire source of my lords, my problems, my lords. That is the order passed by the authority. Page,
Which page? 143.
143. The Annexure 12.
That's the letter.
That order.
143.
Number?
143 is the letter.
Revocation order. Yes. Revocation order. Your lordship may not, my lords, come to read the first part. I will not trouble your lordship. My lord, the last part of the page 143,
Yes.
the last part,
Yes.
last paragraph. Whereas the Director of Mines Odisha
Director Mines of Orissa has requested.
has been requested, write this office order number, office letter number 6562 of 2010-2012 to communicate necessary instruction as the above action has been taken on the voluntary irregularities, on the violation irregularities pointed out by the SLES and communicated by the Director of Mines Orissa, wide letter number 9840 of 25/8/2012. Whereas an opportunity of hearing has been given to the petitioner and the hearing has been attended by Sri J.B. Mishra, representative of the licensee, the Messrs. Rashmi Cements Limited. Whereas the deposition made in hearing dated 2010-2012 in response to show cause notice number 5854 of 29/8/2012 was not convincing.
Yes.
Whereas a penalty of rupees 25,000 only was imposed on the licensee as per Rule 18(1) of the OM Rules 2007 for violation of the MMDR Act 1957 and OM Rules, and the licensee was requested to deposit the same within 7 days. Why this office letter number 6774 of 31/10/2012? Whereas Messrs. Rashmi Cements have
Deposited 25,000.
deposited 25,000. Therefore, it is restored. So what he did was, he said, even if I don't understand your explanation, I'm unable to understand what you're saying, and even if I'm not convinced, but still I levy a...
No, the question of convince will come if you understand.
If you understand. Your
If
lordship
you
is
don't
one
understand, where is the question?
I'm grateful, Manoj. Your lordship is one step ahead of me,
Yes.
Manoj. Exactly, Manoj.
Yes.
Now, in both the cases, Manoj, identical orders have been passed.
Yes.
In both the cases, Manoj. Now, this being the situation, I'll take your lordship back again to this affidavit, page 4.
This affidavit?
Page 4, that statement, yes, affidavit, page 4.
Yes.
This part is, Manoj, important. First part, your lordship saw, Manoj, not understandable.
Not understood, yes.
Then
Page
second, lordship,
Page
on I'll read this. I'll take a little time, Manoj. These two paragraphs have to be placed before your lordship. On 31/10/2012, I imposed penalty of rupees 25,000 each on both the companies as per Rule 18(1) of the Office OM Rules 2007 for violation of MMDR Act 1957. Also instructed both the companies to submit affidavits stating that they shall not repeat such mistakes in future. Being the competent authority, he gives the explanation here in his statement before the police.
I impose
penalty on both the companies as per OM Rules 2007. No instructions received from the Director of Mines Orissa, Bhubaneswar. In the meantime, 2/11/2012, both the companies filed contempt case against me, filed contempt case number so and so before the Honorable High Court of Orissa. We have not received any reference of the complaint cases, contempt of the cases at the office of DDM Joda. On 7/11/2012, both the companies deposited penalty of rupees 25,000 each and submitted affidavits separately not to repeat such mistakes in future. On 16/11/2012, I revoked the suspension orders of the license for both the companies as per Rule 18(2) and 3 of the OMPTS Rules 2007 and issued letters accordingly to all concerned. As per OM rules 2007, if the show cause was not satisfactory, it should have been cancelled. But here, as regards, this is the crucial part.
Yes.
But here, as regards the violations of the mismatch of quantities in the return shown by the companies were clerical errors and corrected by them. These errors have been corrected. This is only an entry, Malad. No physical transfer, no theft, no illegal manners, no illegal mining, nothing. Which has mismatch, which was corrected by them. Regarding shortage, excess of stock, the matter has been referred to be examined by the SLEA. As regards the transportation without having valid license, as the company was issued with permits for transportation, in the second one they say, in addition to certain mismatches, which was again clerical, they say that you did not have a license for a period of 18 days. And that period also you did some transportation. That explanation also he gives here. That will cover the second case also.
Yes.
As regards storage, excess of stock and the matter has been error, as regards the transportation, without valid license, as the company was issued permits for transportation by the office, his own officers issued permits for transportation, and the valid license transportation by this office, and as the companies filed WPC, so also contempt cases in order to comply with the orders of the
Those things you have pointed out.
Mal.
So one thing you are saying that is a clerical error. Second is valid transportation permission was granted.
There was permit. Not that TP permits was there.
That was made the basis for the
second case. For the second case, in both the cases, there is some mismatch regarding this entry.
And clerical error.
Clerical error. And secondly, in the second case, it was covered by a permit. Now, in that context, that is the entire case. Nothing more than that. This explanation of the DDM.
What is this document, by the way?
This is the statement of this police paper. This came with the police paper.
Is it part of the charge sheet?
This is part of the record. Before the
statement.
police paper supplied to us. Yes. Trial court record.
Statement.
Yes. This record statement. Your Lordship will see the page 2. Statement of Sri Ballabh Charan Naik. Statement. Police.
Is it 161 statement?
Yes, madam. This is part of the court record.
Yes.
This has been managed by
yes, I understood it.
SKSN, Inspector Vigilance Cell, Cutter. This statement. Now, this part, this explanation part, that he is convinced that this is a clerical error and that he could not understand that. Not satisfied with the explanation and not convinced and not understand. Actually, he shouldn't, even that convinced could not have been written because he did not understand. He did not. I need not have been imposed a penalty also in this case.
25,000
forget it, let us pay it and
that's a different story altogether. You leave it there.
Get it out of
there. But the allegations are, he himself says that it's a clerical error.
It's a clerical error.
And transportation permission is granted to you.
So where is the question of improper paid, some improper gain or some monetary gain, 13(1)(d)?
Yes.
Where is this? This is the entire case before your Lordship.
I understand. Yes. But see, you have referred to different pages. I will only suggest you.
I'll give a note.
Give a note and whichever paper you are, sometime you are referring to this paper, that paper.
No, I'll give
in one place so that while dictating.
I'll give a note so that this Lordship will be able to track my argument.
Easy. Yes.
Great.
Yes. Objection.
Because of the perception on both the cases, the Lordship notes, license is a signed amount for transportation, storage, and trade.
Yes. Yes.
Both the companies are sister. It must be one of them. Head of this one. And in first case, the case of the prosecution is that they have got the license for self-consumption.
Self-consumption.
But they violated the license condition and made the estate. When a state rule scrutiny committee enforcement department detected the mistake and reported to the department.
Accordingly, MPR case was registered before the JMMC. That was pending. And then subsequently.
Because of these violations, you have cancelled the license.
No.
And revoked it subsequently.
No,
Thereafter, again.
Not our case. That is not our case.
And then you suspended.
No,
they went to the High Court.
That is not our case.
You sought permission to file a review petition in the High Court.
No,
Instead of review petition, you're going and filing a criminal case.
No,
that's the case.
Not our case.
Right. Okay. Okay. Let us see.
It has been misinterpreted. Also, can you see? Inquiry his.
Where are you reading?
Also, kindly come to try to go in there. The case of the prosecution is not said there.
Yeah, hard copy then.
Just one, my learned friend, please, just one. I just forgot one. I'm not meaning to disturb you or interrupt you. Just these are date point out. Supreme Court order was on 3/2/2014.
I noted that.
And the FR comes in.
I noted that.
19th.
Those two.
19th.
I noted.
Only those two.
I noted that. I already noted.
Dateful man. That's your lordship. Those are the two dates. That's
He's.
The case of the prosecution is.
1 minute. Your counter. The counter. E-filing. Right, sir. Achha. I thought if it's there, I can. You know. Dekho, actually. You proceed. Proceed.
It's prosecution MPR case was registered before the JMMC for that publishing. And thereafter, it's no notice was issued. In last case of the prosecution is that he has exported the materials, I don't know, which were against the license, which are made for self-consumption, but he has done that.
Show me the license.
Because can you see para 4.
Para 4 of?
Para 6.
6 point?
6.1.
1. I'm there. Page 6.
MS Rashmi Cement Limited was initially granted license bearing number 15463 dated 25/2/2008 for procurement and transportation of iron ore for self-consumption purpose.
Yes.
However, the said company dispatched 3955 MT of iron fines in the month of June 2009 and 361.790 MT of iron fines in the month of August 2009 to Gangavaram Port for export as per their monthly term in the Form E. And your lordship, kindly pause a moment. They are saying that, they are explaining that it was a clerical error. I will show in the investigation how it is not a clerical error. It has been done purposely and how that thought they have claimed. The same illegality, your lordship, the same illegalities were detected and reported by the state people required for appropriate action by letter dated 25/2012. Your lordship, kindly ask the date.
25/8/2012. Yes.
There was total quantity 7616.790 MT iron fine had been dispatched by the said company, violating the license condition.
Yes, I got it. Yes, I got
That
it.
is self-consumption. They have done the extra.
Show me the license.
And the license condition that is there in the charge sheet.
Show me the license. Let us see, understand whether it is for captive use or it is for.
They are not issuing.
But let me see that.
Also, can you say
If your entire case is that 101 of the petition. Okay. Yes. Okay, 101. Yes.
First state.
Yes.
Third line. That is table.
Yes.
15463 dated 25/2008 valid up to
That table.
Table.
Yes.
Valid up to
Procurement for self-consumption.
for self.
Yes.
You also got it?
Yes, I got it.
Then they have done it in the month of June and August. They have done extra.
Yes, self-consumption, right.
Then by that within that 2 months, 7616.790 MT, I don't know, fines they have dispatched. They have exported.
That is 25 to 2008 to 2010. Where you have
কি মাসে জুন 2009 এবং অগস্ট 2009 they have done the export to the tune of total quantity 7616.797.
Yes.
So what's the quantity?
That time it was meant only for self-consumption.
They cannot do that. And on the basis of statutes for the report, action has taken.
Hey, what is the consequence of this? Consequence of this is cancellation of license, which you have done, tasted yourself, judicially scrutinized, you lost it up to Supreme Court.
That is not our. Again, I'm coming to that. I'm taking your valuable time.
Yes.
Can you see? Because it is required. Unless that if I overlook the same, we cannot cover the point. The point on the north side is that we have lost prosecution against the principal accused public servant for showing undue official favor by passing an order which is not permissible under law, only to show favor to the company. That is the crux of the prosecution. We are not. They are placing the reliance of the Supreme Court judgment and of this court order, which has been passed on the concession of the Lord Advocate General, to the effect that the direction given by the director to cancel the license is not
statutorily not permitted, but yes.
The law says if the license so cause reply, you also can. I'm coming to that. You also got that point. Then paragraph 6.2.
6.2.
6.2. Yes.
Again, 6.2. Okay.
It is after even during investigation that during the period April 2009 to March 2012, there are opening balance, so answer that is balancing the dekha. Thank you. It is on from there.
Yes.
Then 6.3. So cause notice was issued. 6.1 notice.
Counter 6.1, 6.2. 6.2. Okay. Yes.
The export illegality was justified in the 6.2 because there was an excess quantity was also detected. That's the last line of that 6.2.
Yes.
Then 6.3. So
there is excess quantity of 1, 2, 3 to 6 point metric tons.
Size found.
Yes.
Then 6.3. So was notice was issued by the deputy director, the principal commissioner. On 30
Who has died? Who has died in between? Yes.
30 for filing its so-called reply within 7 days.
Yes.
And its license was suspended until further order. MPR case number 4 was 2012 was filed in the court of JVS for illegal mining transaction without legal access. So we are not on that. They filed the MPR case. After detection, the MPR case was filed.
That was going parallelly. License is going parallelly here. MPR case was going parallel. Yes. Yeah.
It is simply 6.4. So much reply was filed on 3 in our general part. Thereafter, WPC number 1794 to
Yes, he has already pointed out it. Went to Supreme Court and all. Yes.
The lordship kindly see the WPC number 5. The WPC number first filed by the company challenging the so-called notice and the disposal because delay was in disposal of that so-called reply. On 48, that which was disposed of by reasonable court with a direction. What was the direction? Your lordship kindly see that has been quoted.
To consider and dispose of the same in accordance with law. Within a period of so. Yes.
Direction was to consider the same dispose of them in accordance with law.
Yes.
Then 6.5. On 48/2012, on this point, he solicited the instruction from the director mines for taking further course of action in view of the Hon'Ble High Court's order. And on the same day, he sought for an instruction from the on the same day he took up the issue of it. Then we are not even admitted. They are figures. Oh. Thereafter,
this is the complicity of the officer who died.
We are an officer. First.
You don't want to press anything against them?
No, because of how the conspiracy is going on, was going on, I'll show you.
If the principal accused goes, how will you bring 120p and prove it?
if the court is there, I will show the judgment, it can be stand.
No, it can stand, but how will you prove it? The principal accused goes. Offense will not go, but see, again, Gansing is also, you have to see, if there is a blink chance of conviction, why should you put them to trial?
Because it's conviction, so far as prosecution document says, you will be convicted.
Okay.
Then your prosecution can see.
Yes.
DDC also 2012 without getting instruction and the what was he written to the director, I will show the document. He says the so-called reply is not convincing. And the illegality I will show.
But in the same time, he says that I could not understand.
Because investigation se consider what is the evidence and value? Number one. Number two.
If he understands, then only he will convince.
One man he has retained that.
Anyway, I understand it. Yes, I understand. Yes.
DDC he passed away. Those so-called reply was convincing, not convincing. He has given in detail how the illegalities has been pointed out.
But at the same time, he says that it is a clerical error and all these things. Yeah, so
investigation level. Then you also can see DDC also without getting instruction from the director minds, the so-called reply filed by the transmitted was not convincing, and company has violated. It has also written company has violated the license condition as per Rule 2007. Therefore, he passed order imposing 25,000 fine,
which they have paid and all. You come to
that is the problem.
Yes.
He cannot pass order. That is so complicity. The lawsuit can see the order has passed. 25,000 fine as per Rule 18(1) of the 2007 violation of Pension Act 2007 rule, and he has also ordered that the license was requested to deposit the same within 7 days of receipt of the order and submit an affidavit stating that he will not repeat that mistake again. Accordingly, the license was submitted, deposited the money 25,000. Then your lawsuit kindly see para 6.6. What is the provision of law says? Section 9.
The competent authority may at any point in time during the tenure of the license suspend the license for breach of any of the terms and conditions of the license.
Before cancelling the license,
Yes.
He may withdraw the order of suspension and allow license to carry on. Otherwise, the competent authority, after giving opportunity of being heard the license, cancel the license by order in writing, communicated the license, and also keep the security. That's the provision of law. He says that this is not convincing and explains he was violating the license condition. Otherwise, then I'm complicated. Then para 8,
section 18(1). Yes.
Also to undertake illegal mining, transport or stores any mineral otherwise than with the provision of section so and so.
Illegal mining.
Illegal mining also coming without license or we can 2 years in extent imprisonment for 2 years, or with the fine which may extend to 25 rupees, or with both. In the case of continuance of illegal mining, they get additional 500. So
25,000.
He has passed 25,000. It is not permissible on one hand.
Because or is used. Or.
Which is more than the prescribed under law. 25,000. That is the reason he deposited the same. He could have challenged the same. The petitioner could have challenged the same. It showed the complicity of the petitioner for their economy.
Yes.
And another aspect, the license, he has violated the license condition. He found that local reply. He found the license has violated the condition and also transported the violation and that his so-called are not convinced. Therefore, he should not, instead of passing the cancellation order, he revoked the license of suspension order and told him to deposit 25,000 and further. This is the he has acted beyond the permissible law and his authority.
Yes.
That's why Vigilance Department proceeded against him, taking the case of the prosecution
and invoke 120B and
that is the case of the second case. In the second case, without license, two aspects in second case. Self-consumption, they exported it. Second, he has in the second case.
What are the under the rule? What are the procedure? Contempt, no. I suppose 25,000 rupees penalty is imposed. If it is violative of any that condition, 18(1), or you are agreed, the government is agreed. What is the remedy available to you? No, he passed the order. If that pass, the order is motivated order because they are under the influence of these people. That's your case. So if in that is the case, they have complied with the order. If the order is illegal, what is the remedy available to you? The government, what is the available? Prosecution is one. But have you challenged that order at any stage that this order was illegal and it was passed in connivance with these people?
Since our case is he abused his official position, so undue official favor to the company. Then company deposited instead of 500, he deposited the 25,000 of fixed. Because they are conspired with each other and he passed the illegal order that was compliant.
Show me the sanction. Show me the sanction.
The intention of the company was not.
Show me the sanction order.
Sanction?
He died. He died. Oh, sanction against this officer. He is already dead. Do you have a sanction order before charge sheet? Just show me whether you have taken into consideration these aspects. You just remember, you tell me that I want to see the sanction.
Second case.
Yes.
Had a license.
Cognizance order.
There was no license.
There was no license for the relevant period. They have done the.
Okay, here the license was there. It is only for self-consumption.
There
No license.
They done the export and also without valid license they have done the export. So this is the case of the prosecution, and prosecution case is the principal accused has abused his official position, shown undue official favor in conspiracy with the petitioners, and thereby facilitated the company to make the transfer, revoke the license, thereby they have facilitated the company to do the transportation of items. This is the case for which the offences are made up. And another aspect, you will also be putting with that larger that after vigilance in the dropping of the case in the Supreme Court,
yes,
the vigilance take up the investigation. That is not correct. You will also kindly see para that has also been clarified.
Yes,
Para 6.7.
yes, I'm there. On the basis of responsibility, government officers still manage to
It is in terror. Also kindly see the date there saying that the date when the they are saying that the illicit whether terror. Government recommends the matter to the Vigilance Department, the OP to take up the issue for appropriate legal action against the guilty as regards the illegality charging of official position acting in passing order beyond the power as well as against the goods in disclosing the so-called reply and illegally revoking the license, so thereby facilitating the company to obtain criminal. Accordingly,
the Supreme Court order is 3/2/2014.
Counter the not even in the High Court. No. In the High Court counter, the DDM never said. Why is vigilance in? How do I know that vigilance is against me? If the was there any notice from vigilance?
Anyway, now he is trying to explain this part. Okay. It was initiated prior to the Supreme Court order. That's what he was saying.
Inquiry was opened. Inquiry was conducted in presence of the accused person by the vigilance team. And after thorough inquiry,
in the instant FIR registered on 19/2/2014. Okay, 13/2/2014 is the Supreme Court order.
Right. So now it is not within the. It is not the case. They cannot say that it was not there within their knowledge. The vigilance take up the inquiry. They participated in the inquiry. They failed to explain to, and the document was seized, and your lordship will find the export portion is a political error. That is not political error. That has also been revealed in the investigation.
Yes.
468, 471 would have been added to this against that. Any case, charge sheet was submitted on 15/12/2018. Now cognizance was taken in 2019. Now the petitioner is challenging in 2024. They are challenging the cognizance order.
Yes.
What is the So therefore, and taking various defense please.
Where is that judgment you wanted to show me? 120B.
120B. 120B that is a basic case. The 31D is no more in force. 31D is after 2018, and Honorable Appellate Court has very well clarified that the act committed, the act prevailing during the period offence was committed will be applicable. So that plea will not be accepted. Second, 120B, even if 420, 120B achieve. Even if 120B is there.
Simpliciter.
Simpliciter, because the connivance itself is an offence, even the offence is not committed. I will show that judgment because I got a past conclusion, I will show it.
Yes.
And I also am placing, I have given and I think number of judgments. At this stage, you are also not that a number of judgments I am citing because I have.
You cite the recent judgment. Don't bring number of judgments. It is already so big volume. And precise point. No inferential and yes.
Passed by the Honorable Supreme Court on that is on 21st November.
Flag. Yes.
ये quantum judgment agent से पहले judgment from taking. Otherwise, there is more point. I am placing.
Which one?
21st November where.
Rajnish Vishwakarma. Yes.
Six of verticality.
Yes.
In the state, but 6 in the state of Orissa, also they will not find.
Yes.
This court has reiterated the well-settled law that while considering the prior petitioner, the trial court cannot consider any document which is not part of the charge sheet. Contrary to law laid down by this court, the High Court has directed the trial court to consider the documents which are not part of the charge sheet at the time of telling of charge. For direction given by the High Court.
No, he is seeking challenge cognizance order.
Cognizance order.
Yes.
So cognizance order, why taking where taking cognizance of offences. So cognizance of offences are concerned in the Sonu Gupta versus Deepak Gupta, and they are relying on one sequence statement and seeking passing up on that one. And they are also relying the Supreme Court judgment under the inquiry report, whatever.
Yes.
That's not part of the charge prosecution record.
Yes.
And on once basing upon the Rajiv Gorov's case in 2022, the Honorable Appellate Court has said that on the basis of 161 or 164 statement, proceeding cannot be passed under section 482. Then I am relying on judgment Sonu Gupta and Deepak Gupta, they are relevant person. It is also well settled that cognizance is taken the offence and not the offender. Hence, after state of having charge, an individual accused may seek discharge if he or she can show the materials are absolutely insufficient for having.
Oh, show me. So give me that judgment.
I am giving the concept of the relevant portion I am giving.
Give.
And another case there in 2020.
It's all right now. Enough.
Yes,
Enough. Which paragraph you wanted to? Okay. Oh, so you have extracted, huh? Okay. I'll read it out. इसको दे दो. ये flag लगा करके.
One clarification, my lord. It is my oath. I have procured the ore after paying all duty. Export has taken place on a valid license. They have not understood the transaction. My learned friends.
He says it was for self-consumption in one case. In another case, there was no license at all.
So,
but somehow you got the valid transit permit and all.
Permit, yes. Permit, it was covered. That period was covered by permit. What has happened? It's only transportation. So this part will be directory. This is not a mandatory unless you link it to illegal. There's no illegal mining.
Mining, yes.
There's no smuggling. There's no theft.
But there is an excessive mining of about 1,
that's
2,
the shortage.
1, 2, 3, 4, 6.
That has been explained. That has been explained. That has been explained by the managing director in the charge sheet that there's a shortage, not a. That's in the charge sheet page. There is actually a shortage, not an excess. You have not understood the transaction. Financial transactions are not easy to understand. Now, what he fails to understand is that export has been done on a valid license. That entire argument would culminate in an offense if the transportation has been done and the ore has been removed out of India. So, what he has been harping on is it is exported without a on a self-consumption license, it has been exported. No, it has been taken up to the Gangavarman port. Now, from the port onwards, it is on a valid license because what happens is the exporter will not take it from Rashmi Cements unless the license is valid.
Yes.
The foreign remittance will not come. If the license is not valid, the Reserve Bank won't clear. It's little beyond the vigilance officers to understand this part. The money won't come. So what has been done, it's an internal arrangement up to the port. This is what they're playing up. And then this discrepancy, my lord, page 107.
107.
Yes.
Yes.
That has been explained.
Yes.
In the charge sheet, this is their document, part of the charge sheet.
Yes.
Second paragraph.
Yes.
It is alleged that during the period from April 1st, 2009 to March 2012, total quantity of procurement, including opening balance, so and so, comes to 2 lakh and odd of iron ore, 217,187.202 metric ton of iron ore fines and 3,971.160 metric ton of sized iron ore. The dispatch quantity being 2,08,777 of iron ore and 52,000
523971.
So and so of sized iron, resulting in a balance quantity of 8,409.480 and
resulting a balance quantity of 8408 of so and so and so and so respectively. Whereas the closing balance is per the
So
written
therefore, that is his calculation. That is the allegation. It is only in documents. The explanation is here. The next paragraph gives the explanation.
it is submitted that the total quantity of so and so iron ore, so and
iron ore, which are reflected in the dispatches of Messrs. Rashmi Cement, would have been reflected in the dispatches of Rashmi Metallics because of so and so iron ore, and one has been actually dispatched. You are picking up documents at will. So and so iron ore size has been actually dispatched on account of Rashmi Metallics, a sister concern of the licensee. After adjusting the above quantities from the dispatch of Rashmi Cement, the total dispatch of iron ore comes to so and so in case of size iron during the period under consideration.
yes, I understand.
Man,
it's done. No, I'll have to rise now for some important.
I'm grateful, man.
Do you need to continue or I'll reserve the judgment? Give it me.
Lordship can close it. Lordship can close it. We'll file a.
And I'll just request you, whatever you have relied upon, those pages only. Those pages only you give with your short written note. Okay, you give it, I'll just sleep.
Common 7.
Yes. Yes.
Any day, 17th is opening, 17th is also court. Your Lordship wants some more.
No, I don't need. If you, for your satisfaction, I'm saying. In any case, I have to go through. I'll read it and come tomorrow. Tomorrow is the first item. We'll conclude it because the continuity will. First item will continuity will be there. We'll finish it. Unnecessary.
We'll conclude it tomorrow as well. First time.
Only 147. Our few matters are left.
I don't know because today some official assignments are there. Your matter is never small. That is there. It's listed today. Why are you after the student? Why don't you leave them?
No, just one second. Everything has been traversed in the rejoinder, but just for your Lordship's court satisfaction, we'll clarify tomorrow morning.
Tomorrow.
Yes, will not take more than 10 minutes.
Tomorrow, all the matters I'll take up tomorrow.
Man, ours is at the top of the list so that the continuity is not lost.
What available? 40-45 to for the urgent. If there is interim order, give short adjournment, otherwise give longer.
139. 139. I was mentioning
Interim order to continue. He is interested in interim order.
139. I was mentioning in before pre-lunch that they have filed the application for vacation of stay. I want to take instruction next week, any day, your lordship may put it, I have not.
In any case, date will be fixed. He'll allow him to apply his mind. He'll fix in such a manner the matter can be taken up.
Interim order.
Tomorrow matter. His matter he has come from there.
But the interim order may be extended.
Interim order. Unless I say otherwise, tomorrow. 7 Saturday. 143 7.
This informant has already said that I don't know.
Tomorrow first case.
Sir was appearing.
Like a reserve with arguments for 7.
Sir is opposing.
Madam, 144. 144, madam, next week.
He will do it.
Madam.
He will do it. Okay, thank you.
Tomorrow first case.
Yes, first item.